Good morning, everyone. We'd like to thank you for joining us. We are expecting the grand final to start promptly at 11:30. We will be slowly bringing in the teams and the judges. We thank you for your patience until we're ready to start. Hi, Stephen. We are now streaming, so please ensure your microphone is off and camera is off. I'm going to whisk you immediately to the competitor's green room, even though they should be joining us shortly. Please accept the invite as soon as you see it. Thank you. Thank you for your patience. We should be beginning shortly. Hi, everyone. Welcome back. We will shortly be beginning today's Moot. We are just welcoming back our today's competitors from the green room. And once everyone has arrived, we will then be welcoming our judges back, and we should be starting shortly. So thank you very much for your patience right now. Okay. It seems that our judges were more technically able than some of our competitors and have returned first, which is a nice change of pace. So what I'm going to do is I'm going to close all the breakout rooms, which will bring everyone back to the main auditorium, and then we'll then be able to start. To help fill the silence, I would just like to say that it was a great opportunity to work with everyone on this year's Moot. And it was very unfortunate that we were not able to hold one in 2020 due to the pandemic, but we have managed to come together in a virtual environment and offer what I hope is a great opportunity for students to practice their virtual skills, an opportunity for all the judges who helped out and were involved to have a fresh look at all the new faces that will be entering the legal industries over the next few years. And it was a wonderful opportunity for me to interact with so many different students and participants from around the world. And we were so impressed with everything that was done. At this point in time, I would like to hand it over to our clerk for the session, Emily, and she will lead us through the rest of today's proceedings. Thank you very much, Emily, and all the judges, and I would like to wish the competitors best of luck. Remember my final thoughts: win, 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 dominate, dominate, dominate to both teams, and have an excellent 2021 IP Moot.
Okay, well, welcome everyone to this grand final of the Oxford IP Moot in 2021. And what I thought I'd do is just briefly summarize the key facts, because some of you may not have been following the competition, and it may be useful for you to understand what's been happening to make sense of the legal arguments you're about to hear. So the Moot is set in the fictitious common law country Erewhon. The appellants are two members of the same corporate family, Hottenhoffer Pharmaceuticals Erewhon and Hottenhoffer Lilliput. The respondent is the Republic of Erewhon. HPE, that's Hottenhoffer Pharmaceuticals Erewhon, developed a drug called ribocraftose, which is used in the treatment of cystic fibrosis. The drug is sold under the name Prozurol. HPE was granted a patent in relation to the drug, and since November 2012 had regulatory approval to market the drug in Erewhon. However, the Erewhonian National Health Trust has not purchased Prozurol, citing the cost, which is 99,000 Erewhonian dollars per patient per year, and attempts to negotiate with HPE have failed. HPE was also granted a number of trademarks for Prozurol. In April 2013, HPE assigned its entire trademark portfolio, including the Prozurol marks, to HL for $1 Erewhonian dollar. On the same day, HL entered into a license agreement with HPE, in which HL licensed HPE to use those marks in return for an annual licensing fee of $20 million. Some years later, an employee of HPE became a whistleblower in relation to HPE's corporate activities, and he or she provided the Commissioner for Taxation with over 300 pages of internal corporate documents. In July 2018, the Minister for Health made a keynote speech at a conference on access to medicines at the University of Erewhon. The Minister announced that the Comptroller for Patents had granted a compulsory license in relation to the ribocraftose patent. The Minister also announced that the government had been looking into the practices of pharmaceutical companies, and that the Department of Industry and Trade would be applying to cancel all the marks held by HL on the basis that the assignment of those marks had been for tax minimization purposes, and that the marks had become deceptive. To substantiate these claims, the Minister circulated to the conference attendees a 31-page dossier of HPE and HL documents, being a selection of the documents provided by the whistleblower. The name of HPE and HL personnel were redacted. The legal issues in the problem cover three IP regimes. The patent aspect covers the question of the circumstances in which the Comptroller for Patents may issue a compulsory license in relation to a pharmaceutical patent. The trademarks aspect asks whether trademarks become deceptive when they are assigned to an offshore entity in the same corporate family, such that those marks can be cancelled. And finally, the copyright aspect has two limbs: whether there exists in Erewhon a public interest offence to copyright infringement, and the operation of the quotation exception in the Erewhonian Copyright Act. In the trial of the case, Justice Davies held that the compulsory license was validly issued. She held that the trademarks had become deceptive and are therefore cancelled. She held there was no breach of confidence by Erewhon, as release of the documents was in the public interest, but there was an infringement of copyright because Erewhon could not defend its release by reference to any public interest offence or to the quotation exception. So we are now in the Supreme Court of Erewhon, hearing an appeal from this decision via the recalcitrant Court of Appeal in relation to patents, trademarks and copyright. Leave to appeal was denied for the breach of confidence aspects. So with that introduction complete, I shall now turn over to Lord Kitchen, who is presiding in the Supreme Court of Erewhon this morning. So the Supreme Court of Erewhon is now in session.
Welcome, everybody. Ms. Morrish, I gather you are going to be opening submissions on behalf of the appellant.
Good afternoon, my lord. I'm actually not Miss Morrish. It appears she had a brief internet connection problem, but she's trying to get back on. I am prepared to go forward if she's unable to, but I believe she's trying to right now.
Well, can I just jump in as clerk? Sorry to now take back charge. Shall we just then do the introductions where we can have the teams introduce themselves, and perhaps as junior counsel, you can represent the senior as well, and then we can have the introduction for the respondent, and hopefully your senior counsel will be back online at that point.
Sounds great. Okay. Well, hello. My name is Karine Kazakevich, and my senior counsel's name is Anna Morrish. Anna will be speaking for 22 minutes, and I will be speaking for 20 minutes, and we would like to reserve 3 minutes for rebuttal.
Well, Ms. Kazakevich, you are showing all the versatility that we like to see in a junior counsel, and I'm hoping that very soon we'll see your leading counsel reappear. I think we now have Ms. Morrish.
Apologies for that. I lost connection briefly.
That's no problem at all. Were you able to hear any of what transpired a moment or two ago?
I heard some of the facts were recited.
Yes, the facts were recited, and in your absence, Ms. Kazakevich has told us how you're going to allocate the time within.
Wonderful.
So you can kick off straight away with your submissions for us. Thank you very much.
Okay, thank you. My lords, my name is Anna Morrish. My co-counsel is Karine Kazakevich. We represent the appellants, Hottenhoffer Pharmaceuticals Erewhon, or HPE, and Hottenhoffer Lilliput, or HL. The respondents in this case are the government of Erewhon. We have 3 submissions for the court. Firstly, Justice Davies erred as a matter of law when she found that the compulsory license was validly issued and that the grounds under 65A1A were met, as Justice Davies failed to make a legal determination of demand, and she made an error of law with respect to reasonable terms. Secondly, Justice Davies erred as a matter of law when she found that the trademarks were likely to deceive and should be cancelled pursuant to 34(1)D of the Trademarks Act. Lastly, as my co-counsel will submit, Justice Davies correctly held that the release of the documents by the Minister of Health was an infringement of copyright. This brings me to our first argument, which you can find at point A of your skeleton. The compulsory license was invalidly issued. Under 65A1A, a WTO proprietor such as Erewhon must satisfy 3 criteria. There must be a product which is patented, there must be a demand in Erewhon for that product, and the demand must not be met on reasonable terms. All 3 must be present. The validity of the patent is not an issue before the court today. However, demand and reasonable terms are. While it only needs to be established that the government fails on one of the final 2 criteria, The government fails on both. This brings me to point A1 of our skeleton arguments. Justice Davies failed to make a determination on demand. However, despite this, I will take the court through the requirements with respect to the correct legal test. In their evidence at the lower court, the government of Erewhon conflated clinical effectiveness with demand. Clinical effectiveness is not enough. It merely tells us about the therapeutic potential of a drug.
Sorry, can I just interrupt you for a moment?
Of course.
I'd understood that the demand was established by the 8,000 cystic fibrosis sufferers, of whom we might expect 3/4 to benefit from a treatment with this pharmaceutical. And they have no alternative available. So do they not represent a demand of themselves, or at least through the trust, which procures the medicines for supply to them?
When we're talking about demand, we're talking about a few different things. What we're talking about is, especially with respect to a pharmaceutical, is there a treatment need? And furthermore, is that treatment need being met? For example, if it's being met with equivalent pharmaceuticals on the market that are available, then there is not a demand for the purposes of 65A1A. I would like to take the court to tab 1 of our Book of Authorities. At tab 1, you will find a case called Brantford Chemicals and Canada, which was heard before the Federal Court of Canada.
Yes.
The court in this case considered the availability of a compulsory license for a chemical called Cysic. Cysic could be used to make the sodium form of enalapril, which is an ACE inhibitor or a blood pressure medication, a certain blood pressure medication. Merck held the patent for enalaprils and their sodium salts.
Yeah.
Brantford Chemicals attempted to establish demand, and at page 16 of the supplementary bundle, you can see that I'll read from paragraph 97. The court states, in this note, I note that the provision refers to the demand, does not include anticipated demand, the future demand, or the potential demand, thereby suggesting that a demand must be one that actually exists.
Mm-hmm.
And then at page 17 of the supplementary bundle, at paragraph 101, the court states, in this case, there was no evidence before the commissioner that SE-based medicines have a therapeutic attributes that ACE inhibitors currently on the market do not have, or that there was any existing demand for medicines with the unique attributes of SE medicines. In this case, Erewhon's statute similarly refers to the demand. Erewhon's statute does not refer to potential, anticipated, or future demand, suggesting that Erewhon statute also refers to a demand which actually exists. As I mentioned, clinical trials tell us about the therapeutic potential of a drug. It doesn't tell us about the actual demand in the relevant marketplace. Furthermore, in order to establish that there is a demand, we must look and see if there are other alternative preparations which are satisfying the demand. This interpretation is supported in case law from other jurisdictions.
Sorry, just before you go on, but is there any suggestion that these patients can be treated with some other drug?
There was no inquiry into that aspect at the lower court, and that is the failure that I'm referring to with respect to the legal test. In order to make a proper determination of demand, the court needs to look at these aspects. At tab 2, you can find a case called Merck and Shinogi, which was heard before the German Federal Court of Justice. I'd like to take the court to page 25, and I'll start reading at the bottom of the page from paragraph 39. The court notes, in application of these principles, the public interest requiring the granting of a compulsory license can be affirmed if a medicinal product for a treatment of a serious disease has therapeutic properties that products available on the market do not have or do not have to the same extent. And then the last part of the paragraph, which is unhighlighted, a compulsory license cannot be granted if the public interest can be satisfied with other essentially equivalent preparations. In that case, the compulsory license was available. It was available because the drug in question had certain attributes which equivalents did not have. For example, it was the only preparation that was approved for use for combination therapy in infants aged 4 weeks to 3 months. With respect to children 12 and under, it was the safest preparation. Alternatives were hepatotoxic to this group. With respect to pregnant women, this drug lowered viral load much faster than alternatives, which meant that the transmission would be less likely from mom to baby. In addition, other preparations had teratogenic effects, meaning that it could cause birth defects. That is how it can be established that there is a demand for a particular drug. If the court is not satisfied with respect to this legal test for demand, the government still fails. As mentioned, all three criteria need to be satisfied. And this brings me to point A2 of our skeleton arguments. It was not established at the lower court that reasonable terms were not met. The government merely submitted that HPE had not been reasonable in their terms because of the costs charged for Prozeral. And when Justice Davies determined that reasonable terms were not met, she made a conclusion based on an error of law, and again, failed to apply the requisite legal test. In order to establish this criteria, the court must look to factors which indicate that the patent holder was unreasonable. We need to look at the negotiations, and we need some point of reference with respect to the price if we're going to come to a determination that it's not reasonable. By way of analogy, perhaps there are other drugs which are actually much more expensive than Prozeral that also treat lung function in cystic fibrosis patients. From that frame of reference, the price would be considered a steal. So in order to determine that reasonable terms were not met, this type of inquiry needs to be undertaken.
Can I ask this? I mean, who does the burden lie on when it comes to exploring the market? I mean, if there were other drugs available, which, as I understand it to be your case, broadly met the same demand and did so at a reasonable price, wouldn't it normally be for your client to adduce evidence of the availability of those other products?
When it came to applying for the license, the burden was on the government. These are conditions that need to be satisfied before the controller can issue a compulsory license. At this stage of the game, the onus is on both of us because some information is within the exclusive control of either party. Yeah. When Justice Davies looked at the case and determined that reasonable terms were not met, she failed to look into the negotiations themselves, and she failed to consider the price of other drugs to determine whether or not the price was overcharged or undercharged. With respect to the negotiations, we need to ensure that the precondition of negotiating for a voluntary license was taken seriously and that they were not just sham negotiations. In BDR Pharmaceuticals and Bristol Myers Squibb, the controller of patents in Mumbai looked at the conduct of the parties. This was consideration of a compulsory license used for a chemotherapy drug. The onus was not met on the part of the applicant because of their role in the negotiations. They merely sent a letter to the patent holder. The patent holder responded with further inquiries, and then 4.5 months went by before the applicant did anything else. And they applied for the compulsory license without really engaging in any dialogue. And for that reason, the controller determined that real effort had not been put out. And in this case, we don't know if the government merely submitted a letter to HPE and then after that made no further inquiries and then applied for the compulsory license. The court must look at the nature of the negotiations. In addition, when we're looking at the economic value of the drug, we need to assess reasonableness in light of other drugs on the market, the economic value of the patent itself. This is consistent with the Agreement of Trade-Related Aspects of Intellectual Property Rights, or the TRIPS agreement. Under 31H of that agreement, the rights holder shall be paid adequate remuneration, taking into account the economic value of the authorization. It is also consistent with case law. In Consolidated Wafer Company and International Cone, the Supreme Court of Canada held that in determining the amount paid for a compulsory license, the lower court correctly considered manufacturing and repair costs of the ice cream cone machine in question, as well as the unexpired term of the patent. In Lee Pharma and AstraZeneca, the controller of patents in Mumbai noted that there were other therapeutically similar drugs in similar price ranges, and for that reason, the price charged for the drug in question could not be considered unreasonable. As there was no inquiry into any of these factors at the lower court, we ask that this court either remit the decision back down for proper determination of demand and reasonable terms, or overturn Justice Davies' decision that the compulsory license was validly issued.
To what extent is it appropriate to leave analysis of the detailed terms of the compulsory license to the later hearing, which is what Mrs. Justice Davis did? I mean, what she seems to have decided, as did the controller, is that the requirements of Section 65A1 were met, in that there was a demand in Erewhon for the product which was not being met on reasonable terms, and then has deferred consideration of the details of the license and the sub-license to any local manufacturer for this later hearing. Why is that not a permissible course for her to adopt?
There's a precondition that the applicant engage in attempts for a voluntary license. If we do not look into the nature of those negotiations to determine whether or not that was a real effort, then 65(2) becomes merely decorative. The precondition of engaging in negotiations for a voluntary license is a requirement, and we need to undertake an assessment into whether or not the parties took that seriously. After that point in time, if real negotiations were engaged and it was still a failure, then the application can be made, and then a compulsory license can be granted, and then possibly the court can determine reasonable terms, given that the parties cannot agree to those terms. That is the typical process.
Could I just ask this? As I understand it, in the clarification that we've been provided of the facts of the case, there's been no argument that the government failed to make reasonable efforts to negotiate for a license as required by Section 65(2). And so is it open to you to take a point on Section 65(a)(2) at this stage before the Supreme Court?
Given the wording of 65A1A, that reasonable terms were not met, the court needs to undertake an analysis of reasonable terms. For example, looking at the price of other drugs with respect to the economic value at minimum.
I understand that, but that with respect is a different point, isn't it? I mean, you're now going back to the 2 points that you began with, namely demand and the question of whether or not product demand, such as it is, was being met on reasonable terms. But the point I'm asking you about is the further criticism that you're making, as I understand your submissions, that there was a failure by the judge properly to consider the requirement of Section 65A, subsection 2, paragraph A.
I'm merely referring to the fact that there is the precondition. And so when we're undertaking an analysis under 65A1A, reasonable terms also refers to the nature of the negotiations. The provision could have stated whether or not a reasonable price was being met. The wording of reasonable terms suggests that more than one factor needs to be considered. And even if we merely rely on the price of the drug, there was still not an inquiry as to why the drug was expensive, or even if it was expensive compared to similar preparations. Taking into account the economic value of the drug is consistent with our obligations under the TRIPS agreement, is also consistent with how other jurisdictions interpret demand and reasonable price.
Thank you very much, Ms. Kovacevic. I think I beg your pardon, Ms. Morris, I've taken too much of your time. You press on now.
Thank you. This brings me to our second argument, which you could find at point B of our skeleton arguments. The trademarks were not likely to deceive and should not be canceled pursuant to 34(1)(d) of the Trademarks Act. Justice Davies found that the marks were likely to deceive as she determined that HL did not retain the requisite level of control over HPE's use of their mark. And this brings me to point B1 of our skeleton arguments. Justice Davies made an error of law when she determined that de facto and de jure control were required. In making this assertion at the lower court, my friends relied on the U.S. Court of Appeals decision of the Seventh Circuit in Eva's Bridal. That case can be distinguished from the case before us today. In that case, there was absolutely no control as found by the court. There was no licensing agreement. There were no powers of inspection. There were no requirements with respect to how the licensee ran their store. And the court made mention of the fact that while control is required, they did not need to make a decision on the level of control. It merely stands for the proposition that sufficient quality control is required, and we do not dispute that fact. The notion that stringent control is required is also outdated, as noted by the House of Lords in Scandicor Developments.
You ask us to adopt the Scandical reasoning in this jurisdiction?
I'm submitting that it's a consideration. It provides persuasion that the court should provide a more modern approach to the control requirements.
Hitherto, in Error 1 have not adopted a modern approach. Is that your submission?
My submission is that it may be the case that this is the first time this is determined at Error 1, and we have no precedents to base our decision on, and so we must look to other jurisdictions. In Scandicor Developments, the late Lord Nichols noted that for their quality control, customers rely on the self-interest of the licensor. They assume that if a license has been granted, that the owner can be expected to have chosen a suitable licensee and imposed suitable terms. They also noted that a change in source is not inherently deceptive, provided that there is only one source of the goods. That is where the requisite control is found. The licensor carefully vets out a licensee that has the capacity, the willingness, and the ability to uphold the goodwill that has been established with the mark. The case before us involves parties that are sufficiently acquainted with one another's capabilities. HPE was in the best position to uphold the goodwill that has been established with the mark, as they have been the only ones to have produced Proserol. For 9 odd years, they have been producing this drug, establishing the goodwill, and ensuring that regulatory standards are met.
Could I just ask this? It's a pretty unattractive position that you're adopting, isn't it? That the profits are shifted out of the jurisdiction to this trademark holder, where the tax regime is much more beneficial to your group as a whole. And yet, despite the subsidiary holding the trademarks, you're inviting us to infer that the parent is acting under the control of the subsidiary.
Trademarks do not import motive into their legal determinations. The tax practices of these two entities are irrelevant to the trademarks issue. When we're looking at a license agreement, what we merely need to establish is what is the level of control that's required and is it being met? And in this case, it is being met. Firstly, we do not agree with my learned friend's proposition that de jure and de facto control are required. However, even if a higher level of control is required, it is being met. There is a licensing agreement between these parties, powers of inspection, powers of review. There needs to be maintenance with, excuse me. May I have a brief moment to conclude?
Yes, of course you may.
Thank you. HL retained the requisite level of control through their licensing agreement. If there was a problem, they could have used those provisions to intervene. And we ask that this court overturn Justice Davies' decision on the matter of trademarks. If I may be of no further assistance, I will leave the floor to my co-counsel.
Thank you very much.
Thank you.
Yes, Ms. Kazakovich.
Good afternoon, my lords. My name is Careen Kazakevich, and I am counsel for the appellants Hottenhoffer Pharmaceuticals Erewhon and Hottenhoffer Lilliput. My co-counsel just spoke on the trademarks and compulsory license issue, and I will now be delivering our third and final submission, which is about the Erewhonian government's indefensible violation of HPE's copyright. When the government deliberately circulated copies of HPE's internal and confidential documents at a public conference, they infringed HPE's copyright. The existence of copyright in these documents and the fact that infringement occurred is not at issue today. This has already been conceded by our learned friends. The only issue that remains is whether or not this infringement is justified. And to that question, the answer is no. I have 2 points to make in support of this position, which you will find under Section C of our skeleton argument. First, a common law public interest defense is not available under the Erewhonian Copyright Act. And second, the quotation defense pursuant to Section 45 of the Act cannot succeed. To begin with my first submission, a public interest common law defense cannot be used by the governments of Erewhon. Currently, the statute contains 40 or so exceptions to copyright infringement, none of which are a public interest defense. Even if a public interest defense has been accepted as a common law defense in other jurisdictions, the Erewhonian Act does not include any language to support the application of a new common law defense now. A rare example of where a court permits this type of defense to be raised was seen in the Court of Appeal of England and Wales decision in Ashdown and Telegraph Group Limited. This case was about the publication of extracts of a secret political memorandum. And in this case, the court notes the availability of a common law public interest defense, but they do so on the basis of Section 171, subsection 3 of the Copyright Designs and Patents Act, which specifically preserves and enables this common law defense in statute. This provision states that any rule of law preventing or restricting the enforcement of copyright on the grounds of public interest or otherwise is permissible. There is no equivalent to this provision in the Erewhonian Copyright Act, and to adopt this provision now disrupts Parliament's legislative intent and their creation of numerous existing, carefully defined exceptions in the Act that reflect an effort by the legislature to consider a wide range of competing interests, including the public interest itself. For the same reasons, when the Federal Court of Australia considered exceptions to copyright infringement in Recollier Constructions and Foskett, the court rejected the existence of a public interest common law defense. The court accepted that copyright is a creature of statute, and that the Australian Copyright Act's numerous existing exceptions, such as those in Erewhon's Act, sufficiently consider the public interest. And to now tack on a broad defense that lacks instruction and direction would not be in line with the intent of the legislation. If Erewhon intended to have a public interest defense, it should be supported by a similar provision to Section 171, subsection 3. And this is especially true because the Erewhonian Copyright Act came out 9 years after this UK Act was enacted. In the alternative, there should be some authorization for the application of common law defenses generally. But neither of these two options are available before you. And rather, the only statutory clue that we have can be found at Section 10 of the Copyright Act. You can find this at the top of page 15 of the bench bundle. And this section sets out when copyright infringement occurs in Erewhon. It begins with the words "subject to this act." And those words imply that any exception to infringement would have already been enumerated in the act itself.
Ms. Kazakevich, could it not be said that the exception that's recognized in the common law could be said to derive from a constitutional right to freedom of speech, and that your argument is effectively to interpret the Copyright Act of Erewhon as if it ousted constitutional rights?
My lord, that is not quite our position. If there was a circumstance where freedom of speech could not be possible due to the protection of copyright, then perhaps there would be a method or a reason to allow for the reproduction. But ultimately, our position is that freedom of speech and copyright protection generally do not conflict. The American case of Baker and Selden establishes a well-known principle in copyright law, which is that copyright protects the expression of an idea and not the idea contained in that expression. This is known as the idea-expression dichotomy. And it leaves a user free to convey the same idea, but to do so in a different form or expression. And as a result, there's a balance that's established for copyright and freedom of speech. Copyright holders benefit from the protection of their expression and any advantages that come from this. And freedom of speech interests are met because citizens are able to freely discuss ideas and convey information. And what this means for the court today on these facts is that the government was not entitled to reproduce and distribute countless copies of verbatim documents. Their freedom of speech in this case allows the government to discuss the ideas in these documents, but not to reproduce them. And this principle, alongside the fact that there is no provision in the Act which allows for common law defenses or a public interest defense, would support that the government cannot now rely on a common law public interest defense in Erewhon.
Surely, Ms. Kazakevich, although of course the concept of an idea-expression dichotomy is commonly dealt with in copyright law, as discussed. In the context of this particular case, the kind of use that the government would have wanted to make to exercise a free speech right required these documents themselves to be produced. The value, the speech to be made, involves taking the documents. You can't really summarize the documents. That's not the point.
In this case, we would submit that the reproduction of the documents has to subscribe to copyright law. And in this case, if we consider the facts here, these were mere allegations of tax practices. This was not a matter of national security or public endangerment. If the government intended to make this point that they were undergoing investigations, they could have done so without reproducing the documents. They could have put out a press release. They could have made a summary. Their freedom of speech allows them to discuss the fact that they are doing so, that they are undergoing an investigation. And this is not prevented by the copyright regime. But what is prevented is the reproduction of 31 pages of documents when there's no exception that the government can successfully rely on. My lords, unless I can assist you further on my first submission regarding the public interest common law defense, I would now like to bring you to section C2 of our skeleton argument. The quotation defense under section 45 of the Erewhonian Copyright Act is unavailable to the government. And for ease of reference, if my lords would like to see the wording of section 45, it can be found at page 15 of the bench bundle. There are 3 requirements that the quotation defense imposes, and I would ask my lords to keep in mind that the government fails on each and every single requirement. First, the work was not made lawfully available to the public. Second, the use of the corporate documents by the government is not compatible with fair practice. And third, the reproduction of the entirety of the documents exceeds any justified purpose. The government must establish each requirement under Section 45, subsection 1 for this quotation exception to apply, and we submit that none of these requirements can succeed. To begin with the first requirement, the German Grand Chamber in the case of Spiegel and Beck considers what it means for a work to be made lawfully available. You will find this case in our supplementary bundle at tab 14, and specifically at page 103. I will be reading from paragraph 89. So that is page 103 of our supplementary bundle.
Sorry, just be clear, what is the proposition of law that you're referring us to this case for?
We're looking to this case to interpret what lawfully made available means. This case specifically interprets Article 5.3d of Directive 2001, whose wording of that quotation defense is substantially similar to the Erewhonian's quotation defense. So we're using it simply as a way to consider what these words mean, since they are not defined in the Act.
Thank you.
Now, this case considered whether hyperlinks to full text of a manuscript were available or online amounted to copyright infringement. And in determining whether or not these manuscripts were lawfully made available to the public, the court holds in that paragraph that this threshold will only be met if the work was made available with the authorization of the copyright holder in accordance with a non-contractual license or some other statutory authorization. And none of these options apply to the facts before you. At no point did HPE share or consent to sharing these internal and confidential documents with the public. These documents were stolen by a whistleblower who shared these documents with the Commissioner for Taxation. And it's unclear how many times they changed hands before making their way to the Minister of Health and eventually making their way to the numerous attendees of a public conference, where they were unlawfully disseminated without HPE's permission. The documents were shared in an uncontrolled environment, exposing HPE's emails and spreadsheets. And this was not an internal government meeting or investigation. This is a public conference that had industry representatives in it, among others. And those reproductions were never consented to by HPE, and they were not authorized by any alternative means either. And therefore, in making these documents available to the public, that action was not lawful. And in particular, these documents were not publicly available before the government's use, which is a specific condition of this first requirement.
Do you say as a matter of law that if the documents were made available lawfully under a public interest defense, that would still not satisfy this test for quotation?
Our position is that a public interest common law defense does not exist in the country.
Heaven forbid that you lose on that point. What do you say the law is? This is a point of law.
In terms of a point of law, well, if we're looking at lawfully made available to the public, then we would submit that that would in fact make it lawfully available to the public under the point of law. But ultimately, that there is no means of bringing this into the public that is.
You say that's not the law. I understand that.
Correct. Ultimately, again, lawfully made available, it would have to come out to the public, even if we interpret this provision differently, if we don't look to Spiegel and Beck in these three requirements, if we just consider a normative understanding of lawfully made available, we're looking for an opportunity that these documents can come out to the public in a lawful way. And our submission is there's simply no way for that to be done. Moving on to the second requirement here, assuming that these documents were not lawfully made available to the public, which is our position, this would already bar the government on using the quotation defense. However, they fail on the second and third requirements as well. The second requirement is that the quotation must be compatible with fair practice. And the Erewhonian Copyright Act does not define fair practice. However, considering how other jurisdictions interpret the concept of fairness in the context of copyright can help inform this analysis. For example, fair dealing is a well-known defense to copyright infringement used in many common law nations, including Erewhon. And this approach to fairness considers contextual factors such as the character of the use and the amount of the work that was taken. Now, similar to Erewhon, the Canadian Copyright Act does not define what it means to be fair. The Supreme Court of Canada, in the case of CCH Canadian Limited and the Law Society of Upper Canada, can be found in our supplementary bundle at tab 15, and the paragraphs I'm about to refer to begin at the bottom of page 107 at paragraph 53. This case is about a group of publishers that sue the Law Society of Upper Canada for copyright infringement because they provided photocopies of materials to researchers at a law library. Now, this case examines fair dealing, and the court identifies 6 factors to help determine whether or not the dealing was fair. Now, we submit that this, of course, is not a fair dealing case, and for that reason, we're not going to analyze every factor now. And while every factor supports HPE's position that the dealing was unfair, I'm only going to discuss the most relevant factors in this submission in order to interpret the concept of fairness. If my lords would like to see all 6 factors, they can look to paragraph 53 at the bottom of page 107. In considering the character of the dealing, the court notes that if multiple copies of a work are being widely distributed rather than one copy for a specific purpose, this will tend to be unfair. The court also considers the amount of the work that was taken and determines that if it's trivial, then there will be no infringement. The decision also considers the nature of the work and whether or not the work in question was confidential. These are the same factors that are consistent with the interpretations of fair dealing in other jurisdictions such as the UK. We see the same factors and values coming up time and time again in determining what fairness means in the context of copyright. And moving to the facts at hand, the government's extensive copying and dissemination at a conference does not support a finding of fairness. The government reproduced 31 pages of confidential documents verbatim that were never intended for the public eye. This is not a trivial amount. This is 31-page physical dossiers that were handed out at a conference to members of the public. And as a result, both the amount and the character of the infringement rules out a finding of fairness. I would now like to bring the court's attention to the third reason why the quotation defense is not available. And that's that the reproduction of the entire dossier does not constitute a quotation. Any reproduction under this defense cannot exceed what is justified for the purpose of the reproduction. And while the German Grand Chamber in Spiegel and Beck did find that in some cases entire works can be deemed quotations, it is nonetheless limited by what is necessary to achieve the purpose of the use. Now, if we consider the facts here, the government's reproduction of HPE's documents is substantial and exceeds any justified use. The Minister of Health wanted to share these documents to discuss claims of allegedly deceptive trademarks. Doing so at a conference for access to medicine is already unhelpful for that purpose, but even if the minister intended to do so, there was no need to use verbatim confidential documents. The attendees of this conference are not judges, they are not decision makers, they are not authorities, and they are in no position to actually need verbatim full productions of documents. And as Justice Davies finds, for that reason, the amount that is reproduced exceeds what can be deemed a quotation under this defense. For all these reasons, the quotation exception must be rejected. However, if the court is unsatisfied, then the quotation defense must still be rejected on the basis of subsection 2 of section 45, which states that where use is made of works in accordance with the quotation defense, mention shall be made of the source. There is no evidence to suggest here that the government mentioned the source of the documents when they were disseminated and when those actual reproductions were made, and failing to do so precludes the defense. There was no good faith effort by the government to put HPE's names on the source of the documents, and even if our learned friends say that this kind of attribution is implicit, we would say that there is still no evidence that every document is specifically attributed to HPE. And that means—
Can I just ask you, Ms. Kazakevich, what the source means in section 45.2, because it distinguishes between the source and the author. So you say the source is what exactly?
We would submit that the source here is Hottenhoffer Pharmaceuticals Erewhon.
Or wasn't that implicit in the disclosure that that was where these documents came from?
In the context of the conference, it may be implicit because they are discussing HPE. However, if and when these documents are further circulated, there is no evidence to suggest that every document is actually attributed to HPE.
Are we concerned in these proceedings with the further circulation? We're simply concerned with what happened at the conference, aren't we?
We submit that the purpose of this provision is that the intellectual property of HPE is attributed to them. And without the government subscribing to the requirements of this defense, which requires that the source is made, the mention of the source is made, then it is possible that HPE's intellectual property will not be attributed. And that's exactly what this provision is trying to prevent. I see I'm coming close to my time, and I would just like to ask for a brief 30-second indulgence to quickly conclude and give you our asks of the court, if that's possible.
Yes, indeed.
Thank you very much. The facts before you today have revealed a pattern of poor and inexcusable decision-making by the government. And just because HPE is a company does not mean it should not avail itself of the protections it has under Erewhonian law. My lords, we ask that you find the following: that the compulsory license was invalidly issued under the Patents Act, that the trademarks were not deceptive and should not be canceled, and that the release of the internal documents infringed copyright. Thank you very much.
Thank you very much. That, I think, concludes the submissions for the appellant, at least at this stage of proceedings. So now we will turn to the respondents, and Mr. Malhotra, as I understand it, you're going to make submissions to us first.
Before I begin, my lords, I want to ask if I'm clearly audible.
You are indeed, thank you.
And before I commence my submissions, my lords, if I could introduce myself and my junior counsel.
Yes.
My name is Sahil Malhotra, and I appear as senior counsel for the respondent, the Republic of Erewhon, along with my junior counsel, Mr. Romit Kohli. I will take 24 minutes to address the compulsory license and trademarks issues, while Mr. Kohli will take 21 minutes to address the copyright issue.
Thank you.
My lords, I will now commence with my submissions. May it please the court. My lords, Proserol is a drug that can significantly improve the condition of the 8,000 cystic fibrosis patients in Erewhon. But HPE charges $99,000 Erewhonian for this drug. Consequently, in the past 8 years, a vast majority of the patients have not received treatment with Proserol. My lords, it was in these circumstances that Justice Davies in the High Court upheld the grant of the compulsory license on Proserol. Further, Justice Davies also ordered cancellation of HL's trademark portfolio on the basis that HL does not exercise control over its licensee, HPE. My lords, against this background, we submit that this court must affirm Justice Davies' judgment on the patents and trademarks issues. And to that end, I will address two issues. First, that the compulsory license was validly granted. And second, that the revocation of HL's trademark portfolio is justified. Turning to my first issue, my lords, if I could draw your attention to the bench bundle, specifically to page number 13.
Yes.
My lords, on this page, you will find extracts from the Erewhonian Patents Act. And towards the bottom of the page, you will find section 65 capital A, subclause 1A. And this is the provision under which the government has sought its compulsory license. My lords, the standard under this provision is that there must be a demand in Erewhon for the patented product, which is not being met on reasonable terms. My lords, as far as this provision is concerned, counsel for the appellants has helpfully pointed out that the two relevant elements that are in contention in the present case are whether a demand exists for Proserol, and secondly, whether the demand is being met on reasonable terms. My lords, our submissions on these 2 points can be found at point 2 and point 4 of our skeleton arguments. My lords, opposing counsel contends that the government has failed on both elements, but it is our submission that we have failed on neither. Turning to the question of demand. My lords, opposing counsel has stated that the government has conflated clinical effectiveness with demand and has drawn your lord's attention to the Canadian case of Brantford Chemicals in order to contend that a demand must not be anticipated, future, or potential. Rather, it must be an existing demand. And my lords, we are in full agreement with that standard. And it is our submission that there is an existing demand for Proserol in Erewhon. And as my Lord Kitchen had noted, we submit that that demand is constituted by the 8,000 cystic fibrosis patients in Erewhon. This submission, my lords, is at point 2 of our skeleton arguments.
Well,
my lords, if you...
Hang on a moment. I think that's not a complete summary of the way the case is put against you, because as I understand it, it said that you failed to provide evidence or background to the court as to the potential availability of other treatments for cystic fibrosis, and that in assessing demand, one must have regard to whether or not the clinical needs of the patients can be met by other products.
My lords, as far as that point is concerned, at the outset, we disagree that that is the standard that must be adopted to determine demand. But even if we are to adopt that standard, my lords, we submit that Justice Davies has considered whether there are other medications on the market for the treatment of cystic fibrosis. If my lords will refer to the bench bundle, specifically to page 5.
This is the judgment itself?
Yes, my lord.
Yes, and which paragraph in that would you like us to look at?
My lord, paragraph 4 of Justice Davies's judgment. If I could point you to the specific line, that would be the 6th line from the bottom of the paragraph. It is the line that begins with the word significant. My lords, and if I may read what Justice Davies has stated, clinical studies suggest that 25% of patients experience a significant improvement in their lung function such that other medications can be withdrawn. My lords, this is a clear reference to the fact that other medications for Proserol do exist in the Erewhonian market. And therefore, Justice Davies has taken into account this particular factor. But my lords, as I had stated, we disagree with the adoption of this standard in the first place. And rather, we submit that this court must adopt the standard laid down by the Controller General of Patents for India in the case of Natco versus Bayer. In that regard, my lords, if I could draw your attention.
Just one moment. Why must we do that?
My lords, the product in the present case is a pharmaceutical drug. And the consumers in the case of pharmaceutical drugs are the patients who require treatment with that particular drug. And therefore, my lords, we submit that this court must adopt this very standard.
I see. And you say there's some helpful reasoning, is there, in this decision of the controller? Very well. You take us to it. Which page is it?
My lords, if you will turn to the respondent's supplementary bundle.
Yes.
To page 3.
Thank you.
My lords, in the highlighted line on page 3, the Controller of Patents has stated that the patentee has submitted the number of patients eligible for the drug is 8,842 per year. And if my lords will now move to page 4.
Yes.
My lord, in the highlighted line again,
yes,
the controller states that it is also not the case of the patentee that there is no demand for the drug, yes, because as per their own submission, there is a requirement for at least 8,842 patients.
Yes, I mean, these are submissions though, aren't they? They're not the reasoning of the tribunal.
My lord, these paragraphs do constitute the reasoning of the tribunal. And what the tribunal has held is that the patients, all the patients who are eligible for treatment with this drug constitute the demand for that drug in India. And my lords, we submit that this very standard is applicable in the present case. The 8,000 cystic fibrosis patients, therefore, do constitute the demand for Proserol. My lord, moving
through the trust, is that the way it works? Through the trust. It's the trust that buys the product, presumably.
My lord, we submit that the 8,000 patients constitute the demand irrespective of the existence of the trust. And that is because, apologies, my lord.
No, that's, I understand, thank you.
Yes. My lord.
Can I ask this, Mr. Malhotra? In this case, the controller appears to have moved from a statement that there were a certain number of patients eligible for the drug to a conclusion that there is a demand. But the mere fact that there are a number of people who are eligible for receiving the drug doesn't really establish, does it, that there is a demand without a wider consideration of what else is available?
My lord, if I could elucidate on the reasoning for why we are relying on this particular standard. My lords, as far as pharmaceutical drugs are concerned, the consumers are patients. And in a system of publicly funded healthcare, such as Erewhon, consumers are not directly confronted with the price of the drugs that they require. And as such, their desire for treatment with that drug is price inelastic. In such circumstances, my lords, they require that drug for treatment irrespective of the price, and therefore all 8,000 patients constitute the demand for Proserol. My lords, once we've established that the demand is constituted by these patients, the only question that remains for consideration is whether this demand is being met on reasonable terms. My lords, the counsel for the appellants has contended that there are several factors that must be taken into account when considering reasonable terms. And we agree that the phrase refers to the entire universe of terms that can attach to a particular product. But my lords, it is also our submission that the primary term which is in contention in the present case is the price of Proserol, as is evident from Justice Davies' judgment itself. My lords, senior counsel for the appellants has stated that Justice Davies committed an error in law because she failed to take into account two particular factors in her judgment. The first being whether there were negotiations between the parties on the terms, and the second being the price of other drugs in the market. My lords, as far as the requirement of negotiations is concerned, we submit that Justice Davies did turn her mind to whether there were negotiations between the parties. My lords, if you will turn to the bench bundle, to page 6.
Could you just give us the paragraph number of the judgment, because I have it separately?
My lord, that would be paragraph 9.
Thank you.
If my lords are with me at paragraph 9.
Yes, thank you.
My lords, if you will look at the third line of paragraph 9, the line that begins with the word proprietor, and if you will move towards the end of that line, Justice Davies states, and if I may read with my lords, both parties also agreed that the Minister for Health had initiated discussions with HPE in relation to HPE licensing other local companies to manufacture ribocaftose, but that this request was refused. And my lords, if you will now move to page 17, where you will find the clarifications.
Yes.
And if you will look specifically at clarification number 4, as my Lord Kitchen had noted, HPE and HL have not sought to argue that the Erewhonian government failed to make reasonable efforts to negotiate for a license. As such, my lords, this particular factor, rather, if I may rephrase, opposing counsel's submissions on this particular factor cannot stand. My lords, as far as the second prong of that standard is concerned, where we must consider the price of other drugs, we disagree with the adoption of such a standard, my lords, for the simple reason that a comparison with other drugs on the market does not establish whether the price of Proserol is inherently reasonable. For the simple reason, my lords, that if we consider the UK, there are two drugs on the market that currently treat cystic fibrosis, those being Orkambi and Symdeko. My lords, Orkambi is sold at a price of £200,000 per patient per year, while Symdeko is sold at £292,000 per patient per year. My lords, evidently $99,000 Earwonian dollars is a lower price, but that comparison by itself does not establish whether this lower price is reasonable. Rather, my lords, we submit that this court has to adopt a very specific legal standard to determine whether the price is reasonable. And that standard, my lords, can be drawn from the decision of the UK Patent Office in the Camborian case. My lords, if you will refer to the respondent's supplementary bundle, specifically page 18.
Yes.
My lords, this is an extract from the Camborian's patent decision. I apologize for the quality of the reproduction. But in the second highlighted paragraph, the Patent Office has stated, and if I may read with my lords, the question of whether terms are reasonable or not falls, I think, to be judged in the light of what the customer is prepared to pay. There is no evidence before me of public dissatisfaction with the price of the machine at the date of the application, end quote. My lords, the standard that emerges from this decision is that there must be a public dissatisfaction with the price in order for the price to be considered unreasonable. And we submit that in the present case, there is a clear dissatisfaction with the price of Proserol. My lords, for 8...
Excuse me, sir. Isn't the point being made in Camborian that people were paying the price? That was why it was evidence that it was a reasonable price, because people were paying it, but no one's buying. The government can't buy. That's why we're here, because it's not being bought at $99,000. So why does the Camborian case help you?
My lords, for precisely that very reason, neither the government nor the patients can afford this price. And there is a clear dissatisfaction with the price, because for the past 8 years, the National Health Trust has been trying to negotiate with HPE for the price to be lowered, but HPE has refused every time. As such,
let me ask you this. We're told, are we not, that this drug is sold at this price to patients in other jurisdictions, and that they are prepared to pay. But why is that not some indication that the price is reasonable?
My lords, while Justice Davies' judgment does reflect that Proserol is sold at this price in other jurisdictions, there are no facts to indicate whether patients are actually paying that price. And there are also no facts to determine what is the nature of the market in those other jurisdictions, whether they have a system of publicly funded healthcare or whether patients have to purchase the drugs themselves. In that light, my lords, it is our submission that merely because there is price parity across jurisdictions does not by itself establish whether the price is reasonable. Rather, considering the fact of the matter on the ground in Erawan, we submit that the price is unreasonable due to the public dissatisfaction with the price.
Let me ask you this too. I mean, the focus of your submissions is on the customer, but isn't it right also to take into account the position of the inventor, the patentee, or the rights holder? Because, as we all know, the costs in pharmaceuticals are not so much in the manufacture of the pharmaceutical once it's received its regulatory approval. It's in the vast cost of the research that must be carried out to put the pharmaceutical company in the position of being able to market the product. It's got to identify a suitable molecule, and it's got to secure approval for it. And there are many failures along the way. So a pharma company has to recoup all of those costs from the products for which it has got approval. Otherwise, it'll go out of business. And why are these not relevant matters to take into account in deciding whether or not the price is reasonable?
My lord, two responses to your question. The first, my lords, we agree that a patent does grant a monopoly to pharmaceutical companies, which permits them to recover their investment costs. But my lords, every patent is granted on the condition that the invention will be used in the benefit of the public. And in fact, the Supreme Court of Appeal of South Africa has recognized this very quid pro quo as being an essential basis of the patent system.
Isn't that putting it a little bit high? I mean, the publication of the invention is a requirement of the monopoly, but it's not a requirement of the monopoly that you actually put it into practical use, is it?
My lords, the entire reason for the existence of compulsory license provisions in patent statutes is so that inventors are encouraged to use their inventions for the benefit of the public and not merely derive monopoly profits from the invention. The second answer to your question, my lord, is that in the present case, HPE can recover its investment costs even after the grant of a compulsory license because it is entitled to reasonable remuneration under the compulsory license. And in fact, Justice Davies has scheduled a separate hearing for that matter. Therefore, my lords, if this court has to strike a balance between patent protection and protection of public health, we submit that the balance falls in the favor of the Airwarnian citizens in the present case.
The trouble I have with that submission, Mr. Malhotra, is that the judge has already decided that $99,000, whatever the figure is unreasonable. And the subsequent hearing will have to start from that finding. And what you need to satisfy us of is whether the judge adequately took into consideration the factors that my Lord Kitchen has referred to, namely the cost to the inventor, the patent proprietor, of developing and coming up with the invention in the first place, and whether that finding is justified, because that is the basis on which the proceedings are going forward.
My lord, I understand the concern, and we do admit that as far as Justice Davies' judgment is concerned, it does not reflect a specific consideration of the investment costs of HPE in Proserol. But my lords, we submit that the factors Justice Davies has taken into consideration was sufficient for her to reach the finding that Justice Davies has. And therefore, we submit that the grant of the compulsory license was valid and must not be set aside by this court. My lords, if I could move to my second issue pertaining to the cancellation of the trademark portfolio. My lords, at the very outset, counsel for the appellants has attempted to distinguish the Eva's bridal case from the US Court of Appeals, a case that Justice Davies has relied upon herself. And my lords, the suggestion from the opposing counsel has been that that case involved an extremely different factual matrix. But my lords, Justice Davies' reliance on that case was not contingent upon the facts of the case. If you will turn to the bench bundle, to page number 19, if my lords are with me.
Yes, thank you.
My lords, if you will look to the second last paragraph on page 19, the fourth line from the bottom of that paragraph, the line that begins with the word Michelin.
Could you give me the paragraph number of the judgment?
My lord, the paragraphs in the judgment are not numbered, but it is the second last paragraph on page 19. It is the paragraph that begins with the phrase, "This argument that licensors may relinquish." Yes, but my lords, if I may quote from the judgment for this court's benefit. The court is...
Forgive me, you wanted me to look at paragraph 19 of your supplemental bundle?
Apologies, my lord. Page 19 of the bench bundle.
Oh, the bench bundle, I'm so sorry.
But my lords, if I may quote for your convenience, what the court states in this judgment is that the sort of supervision required for a trademark license is the sort that produces consistent quality. And my lords, it is this principle that we rely upon, not the facts of this case. My lords, opposing counsel has then gone on to rely on the Scandicor judgment of the House of Lords. And the contention that has been put forward is that customers rely on the economic self-interest of a trademark owner in order to maintain product quality. But my lords, we submit that maintenance of product quality cannot be left solely to this economic interest. And my lords, that is evident from the facts of this case itself. If you will turn to page 8 of the bench bundle, if my lords are with me.
Mhm.
My lords, if you will look at the very top of the page, what Justice Davies states in this line is that HL is entitled to an annual licensing fee of $20 million Airwonian under the license. My lords, this fee is not contingent upon HPE's revenues or sales in a particular quarter or a particular annual year. Rather, this is a fixed fee that HL will receive under the licensing agreement. As such, my lords, HL has no economic incentive whatsoever to invest in the maintenance of product quality while HPE is manufacturing pharmaceutical drugs. This investment, my lords, will merely be a sunk cost for HL. And as such, this is a case where a licensor does not have an economic self-interest to maintain product quality. My lords, the second point that has been put forward.
Ask you a very general question, Mr. Malhotra. To what extent is it realistic to say that a trademark is a guarantee of some particular level of quality? Of course, when consumers buy products with a trademark on, they are relying on the fact that the products they're buying are going to be similar to products that have previously been on the market under that trademark. But is the trademark owner ever guaranteeing that the level of quality is going to stay the same? I mean, what happens, for example, if the trademark owner decides to cut costs and produce a slightly less high quality product? Has the mark then become deceptive?
My lords, before I answer the question, I know that my time has expired. If I may have an extension to answer the question and address the rest of my arguments.
Yes, of course you may.
Thank you, my lord. My lords, to answer the question, we agree that a trademark is not a guarantee of quality in any way. Rather, a trademark only certifies that consistent quality will be maintained under the trademark. But my lord, we also agree that a trademark owner is free to change product quality under its trademark. But my lords, the licensee does not have that authority. And that is the very reason for the existence of the control test, because it is the licensor who must ensure that the licensee is complying with quality standards under the licensing agreement. My lords, opposing counsel in that regard has contended that control is being satisfied in the present case. And that is because HL has retained control through the licensing agreement. But my lords, we contend that this cannot be the standard that has to be adopted by this court. Merely showing clauses in a licensing agreement without their actual exercise or enforcement does not mean that control has been, that the control test has been satisfied. In fact, my lords, Justice Davies has reached that very conclusion, that HL has not bothered to enforce any of the provisions in the parties' licensing arrangement. Considering this, my lords, the appellants cannot escape by merely pushing paper before this court. And on that note, my lords, if I could conclude my submissions, we submit that Justice Davies' judgment ensures that the public can access essential medicines. And it also ensures that the public is not deceived by the use of the trademarks by HPE. As such, my lords, we urge this court to affirm Justice Davies' judgment on the patents and trademarks issues. Thank you.
Thank you very much. Now, Mr. Coley, you're going to address us on the copyright issues.
Before I begin, I just wanted to confirm whether I'm audible to my lords.
You are, thank you.
Perfect, then I'll begin. My lords, may it please the court. My name is Romit Kohli, and over the next 21 minutes, I shall be demonstrating that Madam Justice Davies was incorrect in holding that there was an infringement of copyright by the release of the internal documents. In this regard, I will be making two submissions. Firstly, that there is a public interest defense to copyright infringement in Erewhon. And secondly, that the release of the internal documents fell within the quotation exception in the Erewhonian Copyright Act. Coming to the first submission, my lords, if I could clarify at the outset, the question before this court is not whether the release of the internal documents was in the public interest or not. It has been held by Madam Justice Davies least at first instance, that the disclosure was in the public interest, and this determination is not up for appeal in the present case. On the contrary, the pivotal question before this court is whether it should recognize a public interest defense to copyright infringement or not. My lords, we understand that there is no express public interest defense in the Californian Copyright Act. However, we submit that this lack of statutory recognition is not fatal to the existence of this defense. And in this regard, I will be making two arguments. Firstly, that this defense is rooted in the common law itself and does not require express statutory recognition. And secondly, that the recognition of this defense is also supported by strong policy reasons. My lords will find these arguments at points 7a and 7b of our skeleton submissions. Coming to the first argument, my lords, opposing counsel has stated that the recognition of this defense in the UK is contingent upon Section 171, Clause 3 of the Copyright Designs and Patents Act 1988. My lords, we urge you to take a deeper look at the drafting history of this article. For this purpose, if I could invite your attention to the supplementary bundle, specifically page number 64, which contains extracts from the discussion surrounding the public interest defense in the House of Lords. If my lords are with me.
Yes, thank you.
My lords, if you were to look at the highlighted portion, you would see that when Section 171 Clause 3 finally got accepted as an amendment, Lord Beaverbrook clarified that this amendment merely acknowledges the continuing effect of case law without attempting to codify it. My lords, this fact has also been recognized by the UK Court of Appeal in the landmark Ashdown case. And if I could now invite your attention to the bench bundle, specifically page number 98, which contains an extract from this decision. If my lords are with me.
Yes.
My lords, opposing counsel has stated, and I quote, that the basis of the decision in the Ashdown case was the existence of Section 171 Clause 3. My lords, that is patently incorrect. If you were to look at paragraph number 34 on this page, the court stated, and if I may read with my lords, the other restriction which requires consideration is the defense to a claim for breach of copyright that can be mounted on the basis of public interest. This is not a statutory defense, but one which arises at common law and which subsists by virtue of Section 171 Clause 3 of the 1988 Act. End quote. My lords, since Section 171 Clause 3 is not a codification of law, it is abundantly clear that the public interest defense is rooted in common law and not statute. As a consequence, my lords, this court has the power to recognize the public interest defense. And now that it is clear that this court has the power to recognize this defense, the next question which naturally arises is whether the court should actually recognize this defense on policy grounds. And my lords, that in fact brings me to my second argument. My lords, opposing counsel has stated that the Parliament of Erewhon could not have intended an extra statutory defense and that copyright statutes are a code in themselves. My lords, we submit that this could not have been the intention of the Erewhonian legislature because this would lead to major inconsistencies in Erewhon's domestic copyright law. My lords, it is an accepted fact between the parties that the defense of public interest is available for actions of breach of confidence. We submit that if a similar defense is not recognized for actions of copyright infringement, major inconsistencies will arise whenever we are dealing with information which is unpublished in nature. My lords, the important thing to note about unpublished works is that in such works, the confidential information also subsists in some tangible form. Therefore, whenever there's an allegation of breach of confidence, there will always be a parallel allegation for copyright infringement as well.
But surely isn't that a gross overstatement? There may well be an allegation for breach of confidence of confidential information, which is not reflected in the expression of any particular document which accompanies it. Conversely, there may be infringement of copyright in a case where there's no confidential information. The one doesn't follow from the other, either way round.
My lords, if I may clarify, we are referring to the possibility of parallel allegations in such cases. Take the present case as an example, my lords. There is a parallel allegation because we are dealing with information that is unpublished in nature. All of the cases which have dealt with the public interest defense, my lords, have also dealt with unpublished information, and it is for this reason that there have been parallel allegations of copyright infringement and breach of confidence. But my lords, in such a situation, if the court does not recognize the public interest defense, even when the defendant has acted in the public interest and escaped liability for breach of confidence, he will nonetheless become liable for copyright infringement. However, the court must not allocate differing outcomes in these two causes of action, since the interests at stake are completely identical. My lords, the interest of the defendant in such cases is to disseminate the information as widely as possible, while the interest of the plaintiff in such cases is to prevent such dissemination, rather than protecting the creative form of expression in these documents. For instance, my lords, in the present case itself, HPE and HL are attempting to utilize copyright, which protects creative works, to prevent the dissemination of the confidential information contained in the internal documents. My lords, HPE and HL are not interested in protecting the creative form of expression of these documents, because at the end of the day, my lords, the internal documents are official company documents, which do I sense a concern, my lord?
Mr. Coley, does that mean that what you're alluding to in your submissions is that a different legal standard should apply to different works, whether they happen to be creative or not, even if copyright subsists in them? Why is that right?
My lords, we are not. In fact, we contend that the same standard of public interest should be applied in both of these works when we are dealing with information, when we're dealing with an allegation of breach of confidence as well as copyright infringement. And perhaps, my lord, I can best answer your question by referring you to the decision of the UK Court of Appeal in the Lion Laboratories case, which you will find in our supplementary bundle, specifically page number 110. If my lords are with me. My lords, the factual circumstances in the Lion Laboratories case were extremely similar to the case at hand. That case also dealt with the unauthorized disclosure of a company's confidential internal memorandum, with such disclosure being done by whistleblowers who were the ex-employees of the company. And much like the present case, my lords, the court in that case held that the disclosure was in the public interest. And with that in mind, if you could look at the third paragraph on this page, which begins with, "There is no dispute." The court stated, and if I may read with my lords, "There is no dispute, first of all, that the documents which are the subject of this appeal are confidential, that they were taken by the first and second defendants without authority and handed over to the fourth defendants, whether for reward, we do not know, and that a publication would be a breach of confidence by all four defendants, subject to a defense that it is in the public interest that they should be published now. Equally, there is no dispute that the copyright of these documents is in the plaintiffs, and to publish them would infringe the plaintiff's copyright, subject to the same public interest being a just cause or excuse for their publication." My lords, if you were to now look at the last highlighted line on this page, you would see that the court refused to distinguish between a copyright claim and a confidence claim for the purpose of analyzing the applicability of the public interest defense, which was held to be a valid defense for both these causes of action. In the present case, my lords, in order to avoid the allocation of differing outcomes in two causes of action which seek to balance identical interests, the court must recognize a separate public interest defense to copyright infringement. And on that note, my lords, I will be moving to my second submission pertaining to the quotation exception. My lords, opposing counsel has stated that my client is not entitled to the benefit of the quotation exception because it has not satisfied the mandatory requirements in Section 45 of the Copyright Act. in this regard, opposing counsel has made 4 arguments. Firstly, that the work was not lawfully made available to the public. Secondly, that my client has not fulfilled the proportionality requirement. Thirdly, that the work was not made available in accordance with fair practice. And lastly, that my client has not satisfied the requirement in section 45(2). My lords, I shall be dealing with these allegations in the same order, and you will find these arguments at point 8 of our skeleton submissions. Coming to the first argument, my lords, which deals with the construction of the word lawfully. Opposing counsel has stated that the term lawfully means with the consent of the author. My lords, this article, that is section 45, is a verbatim adoption of Article 10 of the Berne Convention. And this interpretation provided by the opposing counsel is in direct contravention to the drafting history of this article. My lords, when this article was being drafted, there was an express proposal for introducing the criterion of with the consent of the author. However, this proposal was rejected for the simple reason that in many situations, it is difficult, if not impossible, for the person who is quoting the work to ascertain the exact conditions under which the work was made available. But then what exactly does a lawful disclosure entail? My lords, we urge this court to adopt the interpretation provided by Tanya Appellant and Lionel Bentley, who have written the seminal commentary on the quotation exception. According to them, a work is lawfully made available to the public when it is made available in accordance with the law of the country where the disclosure occurred. My lords, in the present case, it is a fact on record that the disclosure of the internal documents is in the public interest of Erewhon. Therefore, it would be inappropriate to now hold that it is nonetheless unlawful for the purposes of the quotation exception, since that would be tantamount to saying that unlawful activities are in the public interest of Erewhon. Therefore, my client has clearly satisfied this requirement of lawfulness. Coming to the second argument raised by the opposing counsel, that my client has not fulfilled the proportionality requirement. At the outset, opposing counsel has conceded that entire reproductions of works can qualify as quotations, but she has helpfully pointed out that their extent must not exceed that justified by the purpose. My lords, in the present case, it was necessary for my client to reproduce these documents, these 31 pages in particular, in their entirety. And perhaps I can best demonstrate this by referring you to our bench bundle, page number 9, which contains an extract from the decision of Madam Justice Davies. If my lords are with me. My lords, in paragraph number 19, the 4th line from the bottom of the paragraph, Madam Justice Davies stated, the internal documents were included in hard copy form in a dossier given to attendees of the conference. These attendees including academics, industry representatives, public servants, students, and most importantly, journalists. My lords, this conference served a number of purposes, the foremost of which was providing the public and informing the public of the activities that are being carried out by HPE and HL. It is for this reason that my client chose to share these documents at a conference which included journalists. My lords, absolutely no newspaper would have published our findings without us authenticating these findings by providing a credible source document. It is for this reason that my client chose to reproduce these documents in their entirety, because he wanted to provide the journalists with an opportunity to see the evidence for themselves. But I see that opposing counsel, do I sense a concern, my lord?
Is that the purpose of the quotation exception, to provide information for journalists?
My lord, even though that might not be a purpose of the quotation exception per se, however, in the present case, this rebuts the argument that was put forth by the opposing counsel that it was not necessary for my client to reproduce these documents in their entirety. The purpose of the quotation exception definitely includes the proportionality requirement, which we are seeking to establish here. But my lords, I see that opposing counsel has stated that my client could have simply described the contents of the internal documents for substantiating our claims. My lords, simply describing, extracting, or paraphrasing the contents of the internal documents would have created a disparity, which would have then allowed HP and HL to selectively release the copies of the internal documents for rebutting the accusations which were leveled against them. This was clearly not an option which was available with my client, and therefore the proportionality requirement has been met in the present case. Coming now to the requirement of mentioning the names of the authors in section 45.2. At the outset, my lords, if I may clarify, when asked about the source of these documents by my lord, opposing counsel stated, and I quote, "We would submit that the source of these documents is Hottenhoffer Pharmaceuticals and Hottenhoffer Lilliput." My lords, to that end, if I could invite your attention to page 17 of the bench bundle, which contains the clarifications. If my lords are with me. My lords, in paragraph number 8 of the clarifications, if you were to look at the last line, it is a fact on record that corporate names, including the names of internal departments, were not redacted. My lords, according to the standard established by opposing counsel herself, we have satisfied the requirement in section 45.2. Therefore, in any situation, it cannot be said that the requirement of section 45.2 has not been met in the present case. Opposing counsel, my lords, has also raised the argument about the documents and the use of the quotation.
Sorry, Mr. Curley, forgive me. Section 45.2 says mention shall be made of the source and of the name of the author, if it appears thereon. You've shown us why you've mentioned the source, but I don't understand how you can say you've satisfied section 45.2. The source isn't the author.
My lord, we understand that concern. And the pivotal part of that statement that you referred to was if it appears thereon. Right. My lords, according to the facts on record, my client has redacted the names of the recipients, the senders, and the people referred to in the substantive text of the document. There is absolutely no indication as to whether these people were the authors of these documents or not. Therefore, it cannot be said that section 45.2 has been violated in the present case. Coming now to the requirement of fair practice. My lords, opposing counsel has stated that due to a lack of jurisprudence regarding fair practice, we need to look at the defense of fair dealing. My lords, while fair practice is a criterion or an element of the quotation exception, fair dealing is a completely different defense altogether. And with respect to the jurisprudence with regarding to the element of fair practice, we submit that there is more than enough in the present case. My lords, according to the official WIPO Standing Committee on Copyright, a quotation is made available in accordance with fair practice if it does not conflict with the normal commercial exploitation of the work. It is for this reason that opposing counsel also asked my lords to look at the character of the documents. My lords, in the present case, the quotation cannot possibly conflict with the normal commercial exploitation of the work because as opposing counsel has herself submitted, these are confidential documents, which were never meant to be released to the public. Therefore, it cannot be stated that my client's use of the quotation would conflict with their commercial exploitation of the work. My lords,
sorry to interrupt. I think I'm right in understanding that no defence of fair dealing was run before the judge. That's correct, isn't it? So,
that is absolutely.
Given that the government has not been shy in running every conceivable argument on this, in this case and on this appeal, I think we can assume that the government didn't think it had a defence of fair dealing. So is that not something we can take into account?
My lords, we contend that the release of the internal documents did constitute fair dealing as well. However, according to the...
You're not entitled to run that case, are you? Because you didn't run it below. And
no, my lords.
Reason.
My lords, I would not like to comment on the concession made by the corporate counsel for my client at first instance.
No.
However, merely because of the fact that we have not contended fair dealing in the present case does not mean that the opposing counsel and HP and HL should be entitled to the quotation exception. I see that my time is about to end in 10 seconds, my lord, if I may conclude. We submit that Madam Justice Davies was incorrect in holding that there was an infringement of copyright by the release of the internal documents, because there is a public interest defense to copyright infringement, and because the release of the internal documents clearly fell within the quotation exception in the Erewhonian Copyright Act. Thank you.
Thank you very much, Mr. Coley. That completes the submissions in the opening rounds of submissions. And now we're going to turn to the rebuttal arguments. Ms. Morrish, are you going to be submitting, making submissions on behalf of the appellant, or will it be Ms. Kazakovich?
My lord, it'll be myself, Careen Kazakovich.
Thank you very much.
Thank you. My lords, the respondents have made 3 submissions that we wish to address. First, with regards to demand, my friends brought you to paragraph 4 of the decision, where Justice Davies made mention of the government's submission regarding how clinical studies suggest certain levels of efficacy. Suggesting is not enough. Proper evidence is needed for this court to make a determination. As noted by Lord Justice Kitchen and as noted by Lord Floyd, this esteemed court requires direct evidence such as comparative analysis in order to make an informed decision, and this is not available. Second, we appeal to this court to consider how this decision could impact our trade agreements in Erewhon and its position in the international space. In 2006, Thailand issued a compulsory license for an HIV medication. And after issuing this compulsory license, they faced threats of sanction from the US. The US put Thailand on the priority watch list in their 301 report. Labs said they would stop introducing new medications. And other countries such as Brazil have faced similar consequences. And such a determination can have detrimental effects on the introduction of new medications in Erewhon. And our current pandemic underscores the need to foster appropriate relationships with innovators when we need to battle serious and infectious diseases that face our nation. There is a real and present danger here that using compulsory licenses without imposing a high standard for demand and reasonableness signals to the international community that Erewhon is not concerned with adequately protecting intellectual property rights. And third, my learned friends consistently used Justice Davies' finding in the breach of confidence issue to suggest that the reproduction of the documents is justified in the public interest. However, the finding on the breach of confidence issue is relating to the privacy of information and does not automatically apply to copyright. That finding does not eliminate copyright protection for the documents themselves. As noted in Hyde Park and Yelland, copyright is concerned with the protection of the form of works in which copyright can subsist and not with the protection of information. There was nothing stopping the government from discussing their investigation and the mere allegations they made. But copyright protection and the law does prevent the unwarranted reproduction of unnecessary and confidential documents when there is no need to reproduce them. If the government is going to play the intellectual property game with HPE, they need to play by the rules. And if they continue not to do so, it is in the court's power today to stop them. Thank you very much.
Thank you. That's very clear. Yes, Mr. Malhotra.
My lords, unfortunately, the rules of this court do not permit us to respond to the appellant's reply.
Thank you very much. I think that must then conclude submissions. So we are very grateful to all counsel, and we will now retire to consider all the various points that you've made to us and reach our conclusion.
Thank you.
Thank you.
Thank you, my
you.
lords.
So thank you very much. Judges are just disappearing. And I think, have the teams disappeared as well? Is it just me now here in mission control? Hello, Zoe. Oops, hang on. Is it you're muted or is it that I haven't got sound?
Never alone. I'm always here in the background to help
Wonderful.
out.
Okay, everybody. So this is the plan. Please do take a moment now if you need to leave your screen to pour another drink, have a comfort break. In a couple of minutes, I'm going to give some thank yous for in relation to the moot. So thank you speech will be during the judge's deliberation. And we're also going to be joined by Professor David Vaver, who is going to say a few words by way of tribute to our former very close moot friend, Henry Carr, who died in July 2019. So I'll just give you a moment to leave the screen. I might ask perhaps that David can be brought onto screen as well to join me. Oh, there you are, David. Welcome.
There I am. Thank you.
Just wonder if there's anybody else. Katrina, are you also behind the scenes and wanting to reveal yourself? And Robert as well might be behind the scenes and wanting to reveal himself. Up there's Robert.
I believe
Zoe's back.
Katrina is currently with our judges right now to help them out with their deliberations.
Okay. So we'll just wait a couple of minutes for people, just as I said, to take a little break.
As I always tell everyone I know, this is a prime opportunity for you to rehydrate, get your teas, get your fruit, your snacks, because we're going to go into the second session, which I promise you is going to be even more thrilling than the first.
Yes. So the plan is we've got we've got some content for during the deliberations. Thank yous. We'll hear from David. Then the judges will come back in. They will say what they want to say. They will announce the result, and then we're going to go straight into the prize ceremony. And Zoe, at that point, we want mooters, they can pour back into this room.
Yes, please.
If you win a prize and you want to turn on your camera and celebrate, and I think, Zoe, you're going to have the recording function on, so we can just pick good frames so that you can get a memento of you winning. See, I would just make a screenshot, but you're going to do it the professional way and make sure everyone looks amazing, right?
I will try my best as always. We don't want any bad YouTube videos out there.
Just a reminder that we're still live on YouTube and this is still being recorded.
Yes, I know. We are talking to everyone. Thank you. That was Admin Michael coming in to make sure that Hudson wasn't about to say something embarrassing or career limiting. Never, you might say. But I wonder whether I might kick off then with the thank yous, given that we've given people a few minutes. So I wanted to start with our sponsors. Allen and Overy, 8 New Square, Kirkland and Ellis LLP, Powell Gilbert, Herbert Smith Freehills, and then our publisher supporters, Cambridge University Press, Edward Elgar, Hart, and Oxford University Press. So thank you very much for our sponsors, in particular that you've stayed with us despite last year's disruption to the moot and the cancellation of last year's moot and then coming online this year. Our sponsors were great in staying with us and continuing to support us. So we thank them very much for that. Also wanted to thank the team at the Faculty of Law. So to start with our moot secretary, Jenny Hassan, who has been tirelessly making sure that you receive all the correct communications and helping deal with your communications and being the sort of go-between between us and the team. So thank you for Jenny for all her work. We've also had assistance from Juliet Franks, who is the interim administrator for the Oxford Intellectual Property Research Centre, and she's been involved in various ways. So thank you to Juliet. Thank you to Michael Collier, who whose voice just came on the line briefly. Michael's done a fantastic job in assisting with all the technical aspects, setting everything up, making sure everybody's going to the correct room and so forth. So Michael, we couldn't have done it without you. And finally, Zoe, please turn your video back on. because not only did Zoe help with the technical aspects of just making sure Zoom works, but also was very much the creative brains behind Moot Google website and all of the content on that website. She makes us look professional, and I love people who make me look professional. Zoe, you've done an amazing job, and this is not actually what you're employed to do. So I'd also like to make a pitch to the law school to please make Zoe employed to do this, because it was fantastic to have your input, and I know the teams have loved seeing your face of a morning or evening or afternoon when they've joined to their Moot. So Zoe, thank you so much for your incredible assistance in that side of the Moot. I'd like to just thank to the clerks who were also involved, very instrumental in being in the Moot rooms, keeping time, and making sure that everything was sorted out with Moot procedure and so forth. So thank you very much to our clerks. The judges as well. Now, we had a team of people marking the written submissions, and I think, I'm going to be honest, I think volunteering to mark Moot submissions is crazy. Because I know what marking written documents is like, and it's, I mean, I love teaching and I love my students, but marking, you will agree, David and Robert, is about the worst part of the job, right? And if these people want to do it, I've got some patent formatives that are overdue, so I'm more than happy to send you some essays about patents to be marked over this weekend. Very happy. I have marking for you to do. I wish to thank the crazy people who agreed to mark written submissions. So the team was led by our chief examiner, Rowan Freeland. So thank you to Rowan for a fantastic job. In fact, not just in just overseeing and moderating the team, but he also helped write marking guidelines and material for the bench memo. So thank you so much. And the team of markers was Ian Starr, Andy Lee, Paul Abbott, Jim Cormack, Alessandro Seri, Rosie Burbage, Quiva Ring, and Sanya Samtini. So thank you to all those individuals for your efforts with marking. We had a squintillion judges through the preliminary and quarterfinals, and I'm going to name all of them. No, I'm not going to name all of them. They know who they are. Thank you to all those judges. We do have a time limit that we need to finish the day. So thank you to our judges throughout the preliminary rounds, the round of 16, the quarterfinals. But I would like to thank our semi-final judges, who comprised David Stone, Michael Screen, and Katrina Smith on court 1, and Melissa Clark, Diana Sternfeld, and me on court 2. And I have to say, I loved my bench. I thought I really loved being on that bench. So thank you to my fellow lady judges for being an all-women panel in court 2. And then, of course, our grand final judges, who I will thank once they're back in, but Lord Kitchen, the recently retired Lord Justice Floyd, and the newly appointed Lord Justice Burse. So that's not all their official titles. I've kind of summarized that for the purposes of the presentation, but thank you to our grand final judges. I also want to acknowledge the academic coaches, I think the coaches are particularly important because we know that you support our Moot year in, year out. We know that in usual times, this is a huge commitment of time to help coach a team, but all the more so in pandemic conditions where many people have had many demands on their time and they could have just let the IP Moot go. It's always a labor of love, and we really do appreciate everything you do to support the Moot. We know that it involves talking with deans and other university personnel to get funding and support, and to have things counted in teaching allocations or admin burdens. So, and I think too is you are central, because what we want the students to experience in this Moot is a really unique and valuable opportunity in their law degree for some intensive small group work. So they're working with their team members, a coach or other individuals providing some mentorship and support. We really think that this is what this is a sort of cool thing that law students get to do as part of their degrees, is this very special opportunity to learn and to be mentored. So coaches, you do that, you're responsible for it. And so you actually give them a bunch of the gift of the Oxford IP Moot. It's you who do that. So thank you. And we hope that we will see you with new teams face to face in the years to come. Final thank you is to our Mooters. We are incredibly proud of you this year. I can barely put it into words how proud I am. I've seen quite a lot of Moots this year, and the quality of the presentation, of the research, it was just exceptional. And I think too, we often hear that overused phrase that it's an unprecedented year, these unprecedented times and so forth. Now, leaving aside whether that's actually how unprecedented it actually is, particularly in a university like Oxford, where I think, Robert, we've talked about a number of points in Oxford's history where plague would have been quite a problem. But leaving aside that aspect, that jokey aspect, I actually feel at times that the ability of students to actually have carrying on anything close to normal is just, it's amazing, right? There is so much background stress and disruption and so forth and dislocation. And so your efforts are just even more impressive in that backdrop. But we hope we've provided also a focus for you. And actually, I'd like to read out a quote that a student from the competition tweeted just after the announcement of the round of 16. So this comes from Sriram Kashyap, who said, and I'm just going to read this out, Oxford IP Moot was part of my life for almost 2 years. And though it's come to an end that I hoped wouldn't be the case, it was a truly great experience. I will look back fondly at this in a few years for being something that kept me going and focused during the pandemic. I just think that's absolutely beautiful, and it really captures what we would hope you are all experiencing. So thank you very much to the teams. The final thank you is to you for your excellent job. And we really do hope that you look back at the Oxford IP Moot as one of the best things you did in your law degree. So thank you very much. So that's that for my thank yous.
Well, before we hand over to David, I think it would be.
Oh, actually, and make sure you thank Katrina as well.
Of course, I was going to thank the Moot organisers, Katrina, for all the work she's done, but above all, Emily, you for everything you've done in writing the problem question, driving it forward in difficult times, even if they're not actually unprecedented in Oxford's history, at least. And yes, I mean, thank you, Emily. You know, the amount of work you put into this competition every year is extraordinary, and it wouldn't be what it is without you. So we're all very grateful. And
actually, I should send it right back at you. So thank you to Robert, who is the professor of IP law, who's provided a lot of behind the scenes support, and yes, to and to Katrina as well, who's been a phenomenal deputy director and has really helped with so much this year as well. So, and everybody else at Oxford as well, who I haven't named. I might hand over now to David, because we wanted to pay tribute to our dear Moot friend, Henry Carr. And what I might also just do is, I'm just going to briefly to share my screen, because I do have a lovely photograph of Henry when he was at the Moot a few years ago judging. So this is a photograph taken after the grand final. This was the UNSW one, and you can see him with the teams and the other judges and Moot personnel. So David, do you want to say a few words about Henry, please?
Yes, I do. Thank you, Emily. I was the former professor of intellectual property at Oxford, and one of the people responsible for getting this Moot off the ground. The picture of Henry that you see on the screen, he is on the right-hand side of the picture. You will see Emily, then you'll see somebody else, and there's Henry with his usual large smile beaming away there. Let me just add my words of tribute to the participants, the organisers, the team coaches, the court clerks or clerks, if you prefer, the lawyers, the patent and trademark agents and attorneys, the academics, the behind-the-scenes computer whizzes, and of course, the judges who have all combined to make the Oxford IP Moot such a success. We all wish we could have been together in person, something we hope will happen next year, but congratulations are due to the way all of you have managed to work remotely across time zones ranging from Australia to China and everything in between. Truly miraculous. I want to say a few words about my former master's student and longtime friend, Sir Henry Carr, who passed away on July the 18th, 2019, after a persistent illness. He was just 61. I meant to say something about Henry at last year's Moot, but as you know, that was cancelled because of the pandemic. I believe that Henry's wife, Jan, Lady Carr, has been able to be present today. Many of you will know the achievements of Henry Carr, but many of you will not. He was one of Britain's leading IP barristers, who was a regular face in every court and tribunal in the UK and Europe that dealt with IP. He found time as well to pursue his lifelong interest in law reform and legal education. More than that, he loved literature, he loved the arts, he loved the theatre, he loved travel, he loved music. Even tried to get me to listen to Philip Glass, unsuccessfully, I may add. He loved his football team, Liverpool. Most of all, he loved his family. And for us who knew him, he himself was an easy person to love. So far as our Moot is concerned, Henry was an ardent supporter of it from its inception nearly 20 years ago. He participated in it as a judge over the years while he was a barrister, and after he took silk and became Queen's Counsel, and after he became a judge of the Patents Court and Chancery Division of the High Court of Justice for England and Wales. In a few short years, Henry made his mark on the bench as a thoughtful and thorough judge in both IP and general Chancery cases. I don't think he was ever reversed. Henry was destined for a great judicial career had matters not turned out as they did. He even handed Donald Trump one of his rare legal victories. Nothing to do with a trumped-up case of voter fraud in Georgia, of course, but rather a case where a trademark troll tried to register Trump TV as a mark of the United Kingdom. Henry had no trouble in tossing the troll and giving the Trademarks Office and genuine trademarks owners plenty of ammunition to deal quickly with abusers of the IP system. Had he been alive, Henry would no doubt have sat today as a judge in the grand final of our Moot. We enjoyed judging, and we enjoyed watching him judge, asking probing questions, but always in a kindly manner and with a smile. He knew what an anxious time this was for the Mooters, and he was only interested in bringing out the best in them. Henry naturally took all his cases seriously. He was well known for the way he meticulously prepared for his appearances in court. That didn't mean that he couldn't have some fun along the way. A lawyer appearing against him in a complicated patent case once bet that Henry could not work the word Merovingian into his argument. As those of you familiar with ancient European history may know, Merovingian is the name of a dynasty of Frankish kings reigning in the 6th to 8th century, although not particularly known as being patent aficionados. As lunchtime drew near with no sign of the magic word, Henry suddenly closed his submissions to the judge, saying, "As Mrs. Merovingian would say, is this a convenient moment to adjourn?" A bemused judge, with no doubt less knowledge of Frankish history than Henry's, could say only yes. Henry probably needed a bigger challenge than that, maybe Floxy Norky Nihil Publication, but I wouldn't have bet against him on that either. I would also add to those mooters that are listening, I do not recommend that method of advocacy to any of you, at least not before you've been in practice for quite a few years. I ask that we pause for a few moments to commemorate a fine man and a fine lawyer, Sir Henry Carr, to signal our sadness in his not being here with us on an occasion that would have brought him and us great joy. Thank you. Back to you, Emily.
Oh, thank you, David. That was lovely. That was really, really lovely. Yeah, such a fitting tribute. So thank you very much for preparing those remarks, and perhaps it might be something that we can also get your remarks and perhaps publish them too on the Moot website as well for people to read later, because that was I think for any mooters who had not met Henry, that I think they would have really had a real sense of his character. So thank you very much for that. I'm going to stop the share now of the PowerPoint slide. I do have notification that the judges have either reached or are very close to reaching a decision, so they will be coming back soon. But in the meantime, David, you did say that you sort of were instrumental in setting up the Moot. How long ago was that?
Well, I think that was nearly 20 years ago, very close to the 2000. It was a project of myself, and two of my doctoral students at the time, who some folk will probably know, Dr. Pina D'Agostino, who is now at Osgood Law School, and Dr. Catherine Ing, who has migrated north to Aberdeen and is holding a fort there. We wanted to do it because we wanted to create a community of students that were interested in intellectual property. They could meet one another in challenging circumstances, intellectual circumstances, but also to enjoy the social aspects of meeting other people, other students, other judges, real live judges, real live practitioners, and talking matters of mutual interest with them. And it has been, I think, extraordinarily successful. Our initial Moot was a modest affair compared to what Emily has created of it, which is this enormous, wonderful Moot, which encompasses so many people from so many continents and with so many different mooting styles, and all of them enjoyable. And I've been sitting in on some of these moots, and my goodness, they are terrific. We've got a terrific bunch of mooters and terrific people that are going to be lawyers in the future, and great litigators if they want to get into that sort of business.
I agree. I sort of sat on a number of moots as well, judged quite a few in the preliminary rounds, and was really blown away by just the standard this year. And it was just like such a high bar that everybody started from, didn't have to give any of the sort of basic advice about advocacy or anything like that. It was really very impressive this year. And I think we do look forward to resuming to an in-person competition, because I think the one thing it's very difficult to create in such a short amount of time and with people in different time zones is just that community. And I think that, David, that was something which was always a value of yours when you and Maxine and you were sort of overseeing the Moot and sort of established, I think that was a real value, this idea that it's actually, as much as it's about a serious mooting competition, it's really about also the links that people build with one another. And it is much more difficult to do that online. We do have teams, we will be opening up the Wanda Me again after the prizes are announced. So we have another opportunity for you to sort of fraternize with one another. And we would encourage you to remain in touch. And if there's anything we can do to facilitate that, then do let us know. But it may well be that some of you can arrange to see one another sort of in hopefully the not too distant future, when we can sort of resume a closer to normal life. So that is something which I agree with you, David. It was sad not to have people in person this year. But we, in terms of the mooting aspect of the moot competition, it was as good, if not better than ever.
It's fantastic, and it's replicating what is happening in courtrooms all over the world now, whereas people are keeping away from the pandemic, and I've been watching a number of courtrooms being run in this sort of way, including live examination of witnesses and all the rest. So this is not at all an artificial experience. It will be, I think, also it will be a hallmark of some future court hearings and litigation when we move out of the pandemic. And obviously not as a regular rule, but it will be, I think, a staple of litigation and courtroom practice.
Yeah, and it actually raises some questions for us in the coming years to think about which aspects of this year's competition we might retain. So we had, and this is something where academic coaches, we would really value your feedback and views in particular, because we will be having a debrief soon to talk about our plans for the future. It's sort of not much time off for us between finishing one and starting planning for the next. But this year we had 32 teams. David, did you ever have 32? Have we hit the actual record or just the recent record? Because you had some big early ones.
You've hit the record. You've hit the record.
We've genuinely hit the record. So it's the biggest moot so far. We don't want to make it huge. We don't want it to turn it into some sort of William Viss style, like massive, like thousands of teams all descending upon us sort of competition. We like the smaller, more intimate sort of focus that we have. But we do need to think in future, we've got teams coming back, about whether or not we will retain 32 teams in the competition with a round of 16, whether we might retain some of the electronic aspects of the advocacy with electronic bundles. So there's various things we're thinking about, but you don't care about that, everybody, because you've just seen Lord Kitchen appear and you're like, we want to now hear from the judges. So we've got various people coming back. So thank you, David, for chatting with me. And now I might hand it over to Lord Kitchen to continue with the judgment and result. Okay, so you just need to unmute, and everybody, all the rest of us, please mute.
May I suggest that we wait for approximately 30 more seconds, and then Colin Burst will be joined. Oh, I think he's just made it back to us quickly. And so all our judges have now returned.
The first issue before us raises an important question concerning the circumstances in which the controller may issue a compulsory license in relation to a patent for a pharmaceutical product. The generic name of the product is ribocaftose, and it's been shown to be extremely effective in treating many individuals who suffer from cystic fibrosis. This is a serious and life-limiting condition which afflicts around 1 in 2,500 people in Erewhon, that is to say about 8,000 people in total. 75% of these sufferers would show an improvement in their symptoms were they to be treated with this remarkable new medicine. HPE was granted a patent for ribocaftose in 2010. It secured marketing approval in 2012, and in 2013 it began to offer the product for sale under the name Prosurol. Unfortunately, the price of the product, which HPE had set at about $99,000 per patient per year, was and still is considered by the National Health Trust to be unaffordable, given the other demands on its resources. The trust has tried to negotiate with HPE to secure a price reduction, but without success. And we are told the trust has also made reasonable efforts to negotiate a license so that it can source the product from another local manufacturer, again, without success. The trust therefore felt it had no alternative but to make an application to the controller for a compulsory license under the provisions of the Patents Act. The controller has the power under section 65A2 of the Act to grant such a license if a demand in Erewhon for ribocaftose is not being met on reasonable terms. Section 65A2 is an important provision, and it reflects a balance by the legislature of two competing considerations. One is to provide an appropriate incentive for innovation. The other is to promote access to new technologies if the rights holder chooses not to make them available or to do so on unreasonable terms. Nowhere is this balance more important than in the field of pharmaceuticals. The costs of developing a new pharmaceutical and securing marketing authorization are notoriously high. It's also a chancy business. Many promising drug candidates fall by the wayside. So the hits must pay for the misses. If pharma companies cannot secure a reasonable return on their successes, they won't be able to invest in further research and development and bear the costs of those failures. But conversely, such companies should not be permitted to hold members of the public or the state to ransom. There's a clear public interest in ensuring that useful medicines are made available to protect the health of the public and to promote social and economic welfare. How then is section 65A2 to be applied, 65A2 to be applied in this case? There can be no doubt in our view that there is a demand for ribocaftose in Erewhon and that this demand is not being met. And we reject submissions to the contrary. The 6,000 Erewhonians who suffer from cystic fibrosis and who would benefit from treatment have no alternative therapy available to them. It's true that the few who can themselves afford to pay the $99,000 per year to secure its provision are able to do so privately. But the vast majority rely on access to medicine through the publicly funded healthcare system provided through the trust. These sufferers presently have no access to ribocaftose, and unless the court intervenes, there's no prospect of them getting it. That, one may think, is enough to satisfy the requirements of the section. There is a demand for ribocaftose, and it's not being met on any terms at all. So it's certainly not being met on reasonable terms. But that cannot be what the legislature intended. It would allow a monopoly buyer, here the trust, to impose low prices simply by holding out. So in a case like the present, the court must consider whether the price demanded by the rights holder is reasonable, and it must do so having regard to all the policy considerations to which I have referred, and in all the circumstances of the case. Approaching the legislation in this way, I think the judge reached the right conclusion. There's no suggestion that the trust is acting unreasonably. It can't afford to pay $99,000 per patient per year, given the other demands on its resources. This is not a case where it can be said to be holding out, and in that way abusing its market position as a monopoly buyer. It's clear that without a price reduction or a compulsory license, it will be unable to access ribocaftose for the rest of the patent term, and there will be no respite for the thousands of patients who benefit from it. HPE, on the other hand, argues that $99,000 per patient per year is reasonable and can point to the fact that it sells ribocaftose at this price in other countries. That may be so, but we have been provided with no details of those countries or sales quantities. They may be more prosperous than Erewhon. And of course, we know there are a few wealthy individuals in this country who can afford almost any price that HPC demands. So overall, this is not a very persuasive factor. But there are two other matters. First, HPE has not provided any details of the costs of manufacturing ribocaftose or its research or development costs. In those circumstances, we can reasonably assume, at least at this stage, that at least the manufacturing costs are not high. Pharmaceuticals may cost a great deal to develop, but usually they don't cost much to make. Secondly, we're now well into the patent term, and 8 years have passed since the grant of marketing approval. In that time, HPE has made no sales to the trust, and so has received no revenues from the trust towards the costs that we may assume it has incurred. It's gained nothing by way of a contribution to its drug discovery program, however expensive it may be. All of these factors point to one conclusion. The price demanded by HPE in Erewhon is unreasonably high. HPE has been the dog in the manger for too long. It's time to cut through the impasse and to order the grant of a compulsory license. The terms of that license will ensure that HPE is paid a reasonable license fee, It will secure the availability of ribose caftose to the trust at a price it can afford, and it will allow a local manufacturer to make a modest profit. The terms of this license and the necessary sub-license will be settled at a further hearing.
The judge held, as the government had argued before her and continues to assert on this appeal, that an intra-group trademark assignment and back license had invalidated an entire portfolio of valuable trademarks. She held that these two transactions and nothing more had resulted, in the words of the Erewhonian statute, in the use of the marks being likely to deceive or cause confusion, despite the fact that the goods in question come from a single trade source and are of consistent quality. At the heart of the Republic's contentions in support of this rather disturbing proposition is the notion that a trademark operates as a guarantee of quality. It argues that once the trademark owner loses the ability to control the quality of the goods sold under the mark, this guarantee disappears and the use of the mark becomes deceptive. No further inquiry is necessary because, so the argument runs, the guarantee of quality which the consumer expects has, unbeknown to him or her, ceased to exist. As I shall demonstrate, the government's argument is based on outdated concepts once favoured by legal purists, but which do not reflect modern Erewhonian trademark law. Firstly, the essential function of a trademark is to indicate the origin of the goods to which it is applied. Only indirectly is it an indication of quality. The mark performs that essential function by distinguishing the goods of one undertaking from the goods of another undertaking. Because of their essential function as an indication of origin, consumers can rely on a trademark as an assurance that the goods that they buy under that mark will be the same as or similar to other goods sold and marketed under that mark, because they're made by the same person. In the present case, there's only been one trade origin for goods sold under the HPE marks, that is HPE. Moreover, the goods sold by HPE are and always have been compliant with HPE's quality standards. At the date of the application for revocation, consumers continue to get what they have always got, namely HPE's goods made to HPE's standards of quality, whatever they may be. There's no relevant deception by the continued use of the mark in this way. Secondly, the government's argument only gets off the ground if it were to be established that consumers are concerned about the precise identity of the person who uses the trademark, owns the trademark. No doubt, in days of old in Erewhon, a trademark was regarded as so personal to the owner that it could not be assigned or licensed at all. In modern Erewhonian society, trademarks can be freely assigned and licensed. Modern consumers, concerned as they are to obtain goods which are the same as those previously marketed under the mark, do not pause to consider the precise way in which control over the quality of those goods is exercised, or the identity of the person in whom the registered trademark is vested. See the lucid explanation of the development of the law in England and Wales by Lord Nichols in Scandicor. The government's argument to the contrary is based on a completely outdated and uncommercial approach. The change in ownership of the trademark and the absence of control in HL do not mean that the use of the mark is likely to lead to relevant deception or confusion. Thirdly, even if I'm wrong thus far, and the consumer is somehow concerned with the identity of the undertaking which owns the trademark, HL and HPE are part of the same undertaking for these purposes. Again, there's no relevant deception or confusion. Fourthly, if I'm wrong and some form of control is required by the legal person in whom the mark is vested, I would hold that there is sufficient control here. HPE and HL have a common interest in upholding the quality of the product sold under marks and a common financial interest. By looking for a legally enforceable power of control, which HL was in fact exercising by asserting legal rights, the judge was conducting too narrow an inquiry It is irrelevant that HL has never taken steps to enforce the quality provisions in the license agreement, and there's been no failure to control the quality in fact. There was no likelihood of use of the mark causing relevant confusion or deception in the present case. The government's attempt to take advantage of the assignment and license is opportunistic and unmeritorious. I would set aside the judge's order cancelling the trademarks and make an order restoring the entire portfolio to the register.
Before the judge, the company argued that the provision of copies of their internal documents at the conference on the 17th of July 2018 was an infringement of copyright by the respondents. Subsistence of copyright and reproduction was accepted. The government sought to rely on two defences. First, that copyright, like breach of confidence, is subject to a public interest defence, and second, that the reproduction of the documents for the purposes of briefing the conference attendees fell within the quotation exception in section 45 of the Erewhon's Copyright Act. The judge noted that in the United Kingdom there is a public interest defence to copyright infringement, citing Ashdown and the Telegraph Group. However, the judge held that the recognition of that common law defence in the UK was dependent on a section of the relevant local legislation, section 171, which was notable by its absence from the Erewhonian statute. The judge noted the presence of Article 3 of our Human Rights Code, which enshrined the right to freedom of speech, but held that the Act was extensive and contained over 40 exceptions and qualifications, none of them amounting to a public interest defence. Therefore, the judge held that this defence was no part of the law of Erewhon, and so, even though the reproduction was in the public interest, there was no defence. In argument, we will refer to the judgment of the Federal Court of Australia in Re Collier Constructions. In Australia, as in Erewhon, there is no equivalent of section 171 as in the UK's Act, saving the common law defence. Therefore, the judge in that case, Justice Gummow, held at paragraph 54, rejecting the submission the defence was part of the law of Australia, that it would be an odd result if this complex of provisions, reflecting an accommodation by the legislature of a range of competing interests, were overlaid with some defence springing from the general law and defined with none of the precision apparent in the legislation. Now, judgments of that well-known jurist always repay careful consideration, and I do not doubt that that was the right answer under Australian law. However, there is what I believe to be a crucial difference between Australia and Erewhon. We have a general right of freedom of expression enshrined in our constitution, whereas in Australia there is no such generally enshrined right protected in that way. Therefore, what is sauce for the Australian goose may not be sauce for the Erewhonian gander. The judgment of the English Court of Appeal in Lion Labs and Evans in 1985 provides a convincing analysis why the common law recognises a public interest defence to copyright infringement. Applying that logic to Erewhon, I would hold that such a defence would fulfil the requirement of Article 3 of our Constitution. The freedom of expression guaranteed by Article 3 must require that free expression, as long as it's in the public interest, should yield to private rights such as copyright. I recognise that the copyright legislation contains no express provision preserving that defence, but I cannot read the statute as thereby purporting to oust the constitutional freedom. Furthermore, it seems to me that to reach a contrary conclusion would be to risk emasculating the public interest defence which we do have to breach of confidence. The judge recognised this, but thought it could be reconciled because the discloser would be free to describe the information in the works without reproducing their expression. However, for material of the sort this case is concerned with, I believe that distinction is unreal. The true public interest is engaged by allowing the public to see the very works themselves, and I would therefore allow this aspect of the appeal. Turning to the question of quotation under section 45 of the Act, I approach the issue on the footing that the public interest defence exists, as I've said. I make that observation having because the court should therefore feel no imperative to distort the meaning of the terms of the section in order to serve as a kind of public interest defence in another guise. The first issue is what is meant by the term a work which has already been lawfully made. There are two questions. First, what does lawfully mean? Does lawfully mean with the consent of the copyright holder or something else? And second, how does the temporal effect, the term already, operate? On the first point, I regret I do not agree with the judge that lawfully is limited to cases about the consent of the rights holder. There are cases in which the work can be available without that consent, such as a public interest defence, for example, and the words of the statute are wide enough to cover that. However, I agree with Justice Davis on the second point. On the facts of this case, when the government made these works available at the conference, they were not works which had already been made available. This was the first time they'd been made available, and for that reason alone, the language of the Act, in my judgment, is not engaged, and therefore this quotation defence cannot succeed. This is not a merely technical point. The purpose of the quotation defence itself, in my judgment, is inherently concerned with allowing public discourse about material which is already in the public domain. Quotation involves a reference by a second person, the quoter, to a work already available. If the work is not already available, then the publication of it for the first time is simply not an act of quotation at all. Nevertheless, I'll briefly consider the other aspects of this issue which were argued. Next is the question of whether the works were quotations, provided their making was compatible with fair practices and the extent of the quotations doesn't exceed that justified by the purpose. The Court of Justice in Spiegel and Beck seems to have contemplated that the corresponding defence in European law could cover the use of a whole work in appropriate circumstances. Like the judge, I'm not convinced that a series of entire literary works can be said to be a quotation, and I refer back to the purpose of the quotation defence I mentioned already. The problem, as it seems to me, is without a prior version of the work already available, it is very difficult to see how you can judge whether the extent of the use now made is fair or justified. I'm not satisfied that this use can be found to be fair or justified in these circumstances. The fact that there was a 300-page source material collection, which was more extensive than the 30-odd pages used at the conference, is irrelevant because that source material has never been made available. Finally, I turn to the question, I turn to the requirement of section 45(2) of the Act to mention the source and name the author. This is mandatory. The versions produced did not comply with the section and the defence is not available. The names were redacted, and it is obvious in my judgment that at least some of those names will have been the names of the authors of the documents. Again, if there had been a prior version published without authors' names, then this problem might not have arisen, but it's not what happened. This difficulty is another manifestation of the attempt by the government of Erewhon to fit a defence which exists for a different purpose into a framework in which it does not fit, just like Procrustes and his bed. Therefore, I allow the government's appeal on the public interest ground, but dismiss it on the quotation ground.
I should add that each of us agrees with the judgments on the issues addressed by other members of the court. Now, that concludes the formal proceedings, and we now come to the part that you're all actually most interested in. And we want to say at the outset that we all feel that the submissions and their content and quality of delivery this afternoon and this morning, respectively, depending on where you are, have been absolutely outstanding. You are all outstandingly good advocates, and the expression top-notch for each of you was used by at least one of us in the course of our considerations. We have gone through this quite systematically. We've been impressed by the command of the law that you have all shown. You've had the relevant legal principles at your fingertips, and you've had the authorities clearly well in mind. We asked you questions, and you responded to them calmly and directly, not always in the way that we expected, but that's the purpose of an advocate. You have to make your own cases. And we found all of that very impressive. Inevitably, in a moot, time is tight, and you focused on the relevant matters by and large, and you minimized reference to irrelevant matters. We all felt that the way you had mastered the bundles and could take us to passages in the authority and identify why they were relevant to your submissions was again absolutely masterly. We found all of your submissions both clearly structured and extremely persuasive. They were all logical. You divided them up in a sensible way. You presented, in our view, the best arguments that you had available to you. And the fact that we've rejected some of them is no reflection on the quality with which they were made to us and their delivery. And indeed, in fact, the harder submissions that you had to make demonstrated your abilities to an even greater extent, perhaps. And you responded not just to our questions, but also to the points that the other teams had argued, both in their written cases and, of course, particularly in the case of Alchemilla, to the arguments made in submissions. And we found all of your submissions extremely clear, and we found that the manner at which you delivered them in this format, which for us is still relatively new, was courteous, clear, helpful, and ensured, and this is perhaps the most important thing at the end of the day, that the points you wanted to make were in fact received and understood, and that we had an opportunity to take them on board. And as I say, overall, you all responded extremely well to questions from us, if sometimes by confessing and avoiding them and moving swiftly on to another topic, which again is an advocate technique that you have to adopt in the course of your practicing careers, which I should say we all hope you will pursue, because you have quite clearly all got considerable talent, and we have no doubt that you will each make a considerable contribution to the law and to your professions, should you choose to pursue them in the form of advocacy. Now, where does that leave us? We have hummed and hawed about this, and it is extremely difficult to choose between you. But at the end of the day, we have all come to the conclusion that by a narrow head, the winner is the National Law University of Delhi, including as the advocates today, Mr. Sahil Malhotra and Mr. Romit Kohli. So we offer you our heartiest congratulations, and we would also offer our heartiest congratulations to Osgood Hall Law School as an extremely worthy and, as I say, very close runner-up, and in particular to Anna Morish and Karine Kazakevich, who have again been absolutely outstanding during the course of their submissions to us today. So we offer our congratulations to the winners and our commiserations, but again, our congratulations to the runners-up.
Congratulations to the respondents.
Thank you for the great
Thank you.
round.
Thank you.
Such a great
Congratulations to the appellants as well.
Congratulations, Delhi. Well done.
Thank you so much.
Thank you.
And thank you, my lords, for your feedback.
Yeah, thank you. I don't know how you did it, David. That was such a close moot from watching it. To try, but you have to, right? We have to have a winner. There is no tie, but it was such a close moot. So I'm going to say a couple of things. And Zoe, do you wish other teams to join the call at this point for the prize ceremony? Because we're about to go to the prize ceremony. And so what congratulations to teams. What I might get the teams to do is just to, at the moment, just switch off your cameras, as we have some other teams that will be joining us soon. So at the moment, as teams are coming in, because we're about to do the prize ceremony, if everyone can join with cameras off, but for the judges and me and Katrina and Zoe, we can keep our cameras on. And Zoe, are people starting to join? Have we got people in the...
We've had a few people joining. Okay. What I think it might be worthwhile reminding, if anyone is looking for the link to join it, you can find this on the Google site, on not only the announcement page, but the links to the Moot. So if you go there, you can find them, you'll be able to join us for the prize giving, and that would be absolutely fabulous.
Yes, because if you are in the room and you win a prize, we would invite you to switch on your camera, and we are recording this, and we will create stills, flattering stills, so that you have something to keep. And we do have, we will be sending out for prize winners as well. You will actually receive physical, tangible reminders, certificates, plaques, various silverware. So that will all be on the way, but we're just going to make the announcements now. We appreciate that given the time zone, it's now after 1 a.m. in Australia, for instance. So not everyone will be on the line. So I'm just going to make the announcement of who's won various awards. And if I can just encourage the judges to please be smiling at various points when we say we're about to use this bit of recording to generate the stills. If the judges can smile, you can feel free if you wish to add on a filter that's just setting that to no one in particular who may want to put a filter on themselves. But before I announce prizes, as we've got people coming into the room, we just had our thank yous. We've already had our thank you speech, but various people on the screen at the moment weren't present at that point. So they were mentioned, but I'd like to mention you again more fully by way of thank you. So that is our grand final judges. You are all three of you long-term supporters of the Moot. And again, you did an incredible job this year, I think, with both your performance during the Moot and then the judgment. Thank you very much. It has been tweeted out there to the world. So the world is aware of what the Supreme Court of Erawan has held, but thank you so much. And I think just to an acknowledgement to Christopher, who has recently retired, but you are still, is this correct, going to be continuing to do some judging on the Court of Appeal? Is that correct? You will still be?
Yes, I can carry on for another 6 years or so. So watch out.
Watch out, indeed. I mean, I don't want to be here being too much of a fangirl, but I really liked Martin and Kogan. I thought that joint authorship case absolutely nailed it. So thank you just to let you know that I like that judgment.
Judges have to be careful about that, because there's always 50% vote in favor of judgments and 50% against.
Well, I'll just let you think whatever thoughts you wish to think about that judgment, which, as I said, I thought was great. The other person to thank, who, as I wasn't here initially, so we sort of wanted to make sure you were back in the room. Katrina, who's the deputy director of the Moot, again has been involved with the Moot for 1,000 years, a long-term Moot supporter, but this year stepped up to help as deputy director, and has been instrumental in a lot of organisation, in particular in relation to the judges, because we had quite a task this year, going from 3 days of intensive mooting, which it's a bit easy to get judges for because you just bust them all up to Oxford, and then they enjoy their judging alongside a finger buffet and drinks. And it's much harder in a virtual environment with the coordination. So did an incredible job with that, also with helping with moderating the written marks and helping contribute to the marking guide and the bench memo. So thank you for Katrina, and also for being patient with me for when I was freaking out about things, to have somebody say, oh my God, and you sort of calm me down. So thank you very much. I've loved working with you. Hope you'll be back in the future to help.
Yeah, it was an absolute pleasure working with you as well, Emily, and I'm delighted with the outcome. I think it's been fantastic.
I think what's a real delight is just it was such a strong grand final where, honestly, I think either team were worthy, deserving winners. They both did an excellent job. It was a really exceptional grand final. So congratulations to all teams. What I might do is I might get started with the prizes, because I know it's getting late for various people. And so what I might do is I'm going to share my screen with the prizes. And so is this going to work, Zoe? If I share my screen, will you still be able to take will you still have enough on your screen to get what needs to be got with all the pictures that everybody needs to see?
We will do our best to make it work, following the KISS method, keeping it super simple, but we're good to go.
So I've got my screen shared, and I've now got the video on another screen. So is that, you can see all that okay? And all right, so I'm just going to announce the prizes. If you happen to be in the room and want to turn on your camera, you can please do so. And there's our actual this year's judges from a few years ago, hearing the University of Toronto give submissions. So there they are in action. So let's now, with our congratulations, we're going to start with prize for the best written submission. And we've got two, we're actually doing this twice, because the first time we're doing it in relation to the teams that made submissions for last year's Moot and who took up the invitation to participate this year. And then we've got a second batch of written submissions made in late 2020. So they'll be the 2021 teams. So for the best written submissions for the 2020 teams, the third place team is actually University of Bern, who are unable to take up the invitation to be here, but they do win that prize. So we will notify them that they're in third place. The second place getter from the 2020 group is the University of Cambridge. So if there's any Cambridge team members who are on the line who wish to switch on, please do so now. And then have we got anyone appearing? Then we've got the 8 New Square winners from 2020 is Swinburne Law School. So if Swinburne's there, it's like 20 past 1 in Melbourne. So they may not be here given it's the middle of the night. So there's congratulations to the 2020 teams for the best written submissions. And now we do the whole process again for 2021. And so in third place, it's UNSW. And then in second place, the team from Ottawa. Very well done, Ottawa, second place. And the 8 New Square winners from the 2021 group are City Law School. So we'll just see if anyone is going to pop on their camera. Oh, we have some.
Hi.
We have
Thank you very much.
A city person. Anybody else? Stay there, Jacob. Stay there. Do you want to? Shall we just make sure we're all smiling for a still? Okay. Zoe, have you got what you need? Oh, can't hear you. Good, great, perfect. Thank you very much, Jacob. You may go away. So congratulations. We now go to the Herbert Smith Freehill's Best Individual Speaker Prize. Now, there were quite a few ties, and we believe in more awards is better. So in actual fact, we're going to have quite a few joints, which probably should have, you'll see what I'm meaning. We have in joint 5th position, Alex Chan from Hong Kong, Jacob Haddad from City, and Kirby Pearson from UNSW. So there are our joint 5th place recipients. So feel free to turn on your camera while I keep going. In 4th place, Marco Montanaro from King's and Linda Shee from SMU. So there's our joint 4th. I shall keep going. In 3rd place, Utsav Garg from Bhopal. In 2nd place, Amanda Wolsansky from Toronto. And the winner of the Nicholas Pumphrey Award in 1st place is Sarah Baloshian from Toronto. So congratulations. If any of these people beyond Marco, hi Marco, well done. wish to join, is that the Toronto girls? Congratulations. Well done. How totally exciting. Anybody else? So should we do a nice smiling bit now? Are you happy with that, Zoe? Good. Well done. Well done. So thank you very much. So congratulations to everyone who got an individual speaker prize. That's judged during the rounds. The next prize we're going to announce is the highest ranked team at the end of the preliminary rounds. And that is Toronto. So well done, Toronto. Do you want to come back? And actually, I need you to come back because I need to do something on my slides. Congratulations, Toronto.
Thank you so much.
And just bear with me a moment because I just need to because this all happened so quickly, I've got the pictures in for who won the oral proceedings and who came runner up. So it's not like this is going to be a big surprise, but let's just get the slide deck right. But congratulations, Toronto, for your excellent effort. Do you want should we have another picture for Toronto winning their second prize? Why not? Congratulations. There we go. Perfect. Now I'm going to re-share my screen now that I've quickly fixed things up. And just all happened so fast. Here we go. Is that back? You can see my screen again. And this will come as no surprise who was the runner-up in the oral proceedings. It's Osgood Hall. So Osgood, please join us again so that we can say congratulations. What a fantastic job you did. Well done. Very well done. Where's the rest of you? Oh, and I see Utsaf has just joined the room, so we might bring him back in a moment. So congratulations. Oh, and there's Coach Jen. Well done. I bet you're totally proud of them. Do you want to say something?
I absolutely couldn't be more proud of this team. The heart that they have shown and the undying enthusiasm for this moot has been a pleasure to coach throughout. For me and my fellow coaches, we are so proud of you, Anna, Alex, and Corinne. Well done.
Well done indeed. Congratulations. So shall we just pause briefly to get this screenshot for them? Good, we've got that. Congratulations, Osgood. Let's move on now. Thank you very much to the Allen and Overy winner, which is National Law University, Delhi. Guys, turn back on. Are you all going to be in the one? Yep, there they've got themselves in the one frame. Of fantastic performance. Really, really well done. And well done to your coach. Coach, do you want to say anything as well by way of congratulations?
Oh, look, these guys have just worked so hard and they're one of the most talented moot teams that I've had the opportunity to work with. And I think they very much, that the hard work reflects in the results. So a huge congratulations.
Congratulations. So let's just smile now so that we can have their screenshot. Got it? Good. I'm going to announce one more award and might ask if David is here with this award to the Government Law College from Mumbai, India. Don't know if any of the girls are online, but this team is receiving this award because they actually stepped in a week before the moot was due to start. We had a team withdraw and they were our first reservist. And actually, I think, Katrina, we were talking about it with the written submissions. I mean, it was really, it was at that point very little to differentiate teams. We had a withdrawal and with less than a week to go, they stepped in to compete. And we just think when you think of the Moot values of hard work and flexibility and so forth, that it was fantastic that they stepped in and then did a great job given the sort of the backdrop that they had. So congratulations to Government Law College for winning the Spirit of the Moot prize. Now, I just wanted to make sure, I saw a few people join who may have missed out on being present for their prize. In particular, I know at least one individual speaker joined. So if anybody from this slide would like to turn their cameras on who didn't get a chance before to turn their cameras on, I think good stuff. Congratulations for coming third. And then there's Jacob. So let's just do another screenshot for you as well. Well done. Thank you very much. Excellent work. If there's anybody else who came a bit late who wants their award, please let me know, but I might just take you through them one more time. So we have Byrne, Cambridge and Swinburne for the best written submissions. The first place is Swinburne, then Cambridge, then Byrne. For 2021, it's first place City, then Ottawa and UNSW. We've got the following students who won individual speaker prizes. Highest ranked team at the end of preliminary rounds was Toronto. The runner-up was Osgood. The eventual winner, National Law University Delhi and Government Law College Mumbai, are the Sir David Vaver. I've just knighted him. Professor David Vaver, Spirit of the Moot winners. So this is what we're going to do now. Teams, I think Zoe is going to put into the chat the WandaMe, is that correct? So teams, please head off to WandaMe so that you can now socialize. Except for the two grand finalists, we are going to, those of you who are in the grand final are going to be put into a private green room with the three judges so they can just give you a bit more sort of feedback, have a bit more of a chat with you. So Osgood and National Law University Delhi, you'll be going across to the green room. Everybody else, we're going across to the WandaMe, and I think, Zoe, is that in the chat? Tell us how to get there. Oops, got you.
I've done the classic, haven't I? That
Yes.
would happen. Okay, so for everyone, please go look into the chat for the WandaMe link. It's also been added to the announcement page of our Google site, so that is there, and hopefully I will be joining you shortly. All my other competitors in today's meet, if you guys want to just hang around or go back into the competitors green room, and then I will move you directly into the judges area, and then we can all have a little mingle. But I'm very excited about seeing everyone else in WandaMe. So yes, please, let's have a quick goodbye there, and don't everyone just disappear. It would be lovely to be able to say bye to you properly.
And Katrina and Robert, do you want to say anything, any final remarks?
Just to thank everyone once again. Enjoy the after Moot party, and we'll look forward to seeing you in the future.
Yes,
absolutely. Yeah, it's been a great moot.
It's been great. So goodbye, teams. We'll see you over in WandaMe soon. And this now closes the Oxford IP Moot for 2021. And we shall see everyone next year, we hope, in person in Oxford for the 2022 edition of the Moot. If you do have a pet who you would like to feature in the Moot problem, please send their photograph and name to me, because we will start thinking too about the topic for next year and the question. So what will happen next year? We've done 3 regimes this year, so will we just go with one of them or another regime? We're already putting on our thinking hats. So thank you very much, everybody, and see you in the future. Goodbye.
Thank you to everyone for watching on YouTube. Please keep an eye on the faculty's YouTube pages, on the website, on our Facebook, on our Twitter account to see what exciting events we have coming up. There's always something really interesting going on within the Faculty of Law at the University of Oxford, and we look forward to getting involved. Have a glorious Saturday and enjoy the rest of your weekend. Thank you very much.